The MSME council matter, works contract is not amenable to the MSME jurisdiction. That matter appear item number 33 under the urgent motion. Well, the same matter, other matter maybe appear along with the 33 matter.
Tomorrow.
33 tomorrow. Urgent motion.
Along with 33.
33.
If it is not taken today, then it will be taken tomorrow.
33.
May I Lordship's kind leave to mention item number 339 of your Lordship's list.
Yes.
339 of your Lordship's list.
339.
Yes, Your Lordship. It's a illegal mining matter. Your Lordship in Birbhum. The initial orders have been passed. Now inspection has been concluded, Your Lordship. The matter was returnable on 10th of November. So in any date, Your Lordship, in the hearing matter, Your Lordship, if your Lordship can be taken. This is a public importance, Your Lordship, that illegal miners, Your Lordship, doing the illegal excavation of the minerals, Your Lordship, from the 2 mines which has been allotted to me. So West Bengal Mineral Development Corporation, Your Lordship, also filed, Your Lordship, complaint against that.
This court? Mines and minerals, that the other court.
So, Your Lordship, we filed, Your Lordship, in this particular matter before the Your Lordship received the jurisdiction, because there are certain, Your Lordship.
This matter was taken up by the Group 9 bench.
Group 9 only.
Yes, Your Lordship. It has already been, Your Lordship, orders were passed.
Direction for conducting inspection on 2 occasions. Inspection has been carried out. So something was going on. We also made complaint because we are the owner of the mine. They are our contractor. We have appointed them. So we also made complaint with the district administration that this illegal mining is going on. Kindly take steps. So they have taken up with the writ petition in terms of the earlier order passed by this honorable court on 2 occasions. So the last inspection report that is required to be taken into consideration. If
it is on record.
No, it's second inspection.
Second inspection is not on record.
For the state.
It's the state, Your Lordship, is to conduct.
They have not supplied any report to you.
No, one report, Your Lordship, they have given us. Another report, Your Lordship, has still not
That
given.
is required to be taken into record. Lordship, kindly fix a date.
339.
339. Item 339 of today's list. IRC Naturals was a state of West Bengal.
339. Tuesday, urgent motion.
I'm grateful, Your Lordship.
Urgent motion, huh?
Milord.
On Tuesday, 2nd February, 2nd December. Take that list. Take the list and put the number.
Yes, my Lord's kind leave, Milord. We had mentioned this matter on 13th of November. Your Lordship was pleased, Milord, to fix this today. This is the doctor's choice matter, Milord, where it's against that violation of Food Safety Regulation Act, Milord, because they were using, Milord, stethoscope in all their products. Milord, I'm being led by Mr. S.N. Mukherjee in the matter. Your Lordship was pleased to fix it today. It has not come up in the list, Milord. I'm only, and this is, Milord, this is for final hearing.
Why it is the file is not here?
But this is for final hearing of the matter, Milord, because affidavits are exchanged. Affidavits are complete, Milord.
Both
all the parties, Milord. For final hearing. আজকের জন্য ছিল হ্যাঁ
একটা ডেট আছে কি
But I'm handing over both the notices, Milord. The first notice on 13th November. Mentioning allowed ছিল mentioning করেছিলাম প্রথমটা mentioning at least
कोई डेट है खाली देखो 2 या 3-4 तारीख को 3 तारीख को कोई खाली डेट है तारीख 8 तारीख 8 तारीख कब खाली है 4 तारीख ना 4 तारीख तो क्रिमिनल मैटर्स वो मैटर होगा हियरिंग मैटर्स होगा 4 और 5 तो नहीं होगा 8 तारीख खाली है 8 तारीख खाली 8 at 2 p.m.
I'm very deeply obliged, Milord. Very deeply obliged.
8 at 2 p.m.
Lordship.
One urgent matter for the urgent motion. Because electricity matter, I as a developer already deposited money for installation of transformer. Then the authority made endeavor to install the transformer, but a club protested. They demanded for the alternate cable, that is covered cable, to use covered. I again made application to the authority being raised. I paid for covered cable, but the authority is not taking any action. The building is totally.
It is not in the list.
It is not in the list.
Which for the other side?
other side.
Have they filed report?
Also.
Have they filed report?
No.
Then new motion में कर new motion.
My lord, this is for non-prosecution. I have mentioned the matter last.
Your Lordship, may I be permitted to
New
mention?
motion and non-prosecution give to all the list to my
Your
court.
Lordship, may I be permitted to mention a matter for inclusion? The interim order in this is expiring in November 2025. The interim order passed
It
in
is
this
going to expire.
in November, Your Lordship, end of
On
November.
which date?
Your Lordship, the order says end of
End
November.
of November.
Your Lordship.
Lordship, may I permit to mention?
End of November. Give the number ये उसको ना उसको extension of time to be mentioned में कर दो. Extension of interim order to be mentioned on 27th कर दो.
Lordship, may I
Yes,
permit to mention item number 291 of today's list. The respondent authority has already cancelled my tender and issued a new tender arbitrarily. And the tender was, the technical bid has been submitted and the matter is urgent, urgent.
Urgency. You have participated in the second tender process.
No, Lordship,
You
they have
challenge that the first cancellation tender notice.
cancellation.
And it was cancelled.
Lordship, it's September.
Then
Sir, Lordship, it's in the new motion list.
291.
291. Messrs. NK Builders versus Union of India.
Yes, it is a new motion list.
Lordship, kindly fix a date, otherwise, kindly fix a date for the hearing, otherwise.
If the affidavits are not completed, how the hearing will come? This is a
Lord-
direction.
Service has been completed.
That's why it has kept in a new motion. What can be done? All urgency. How many matter will be taken once?
Lordship,
By one
kindly
person.
fix it tomorrow, otherwise, the new tender has been submitted already.
291.
Lordship.
Just a minute. एक काम करो 291 को ना 28 को कल है ना 28 को to be mentioned में रखो
I need to mention a matter, Lordship. This is the inclusion.
to be mentioned. Yeah.
Mention in the list, it's a restoration application. The criminal.
You restoration and all the things due to my court office.
May I have, my lord, may I have your lordship's kind leave to mention?
Like,
Yes,
have
one
a-
by one. Yes. For what? It is not in the list. Give it will come in the list.
More matter, very urgent matter.
What is the urgency?
Because the notice has been served, now service complete.
Okay, it will come. Give that.
Here, also can't get fixed. Urgent number.
Fixing will not be all matter will be fixed, and when the other matters will be taken. No urgency. Yes, give all the letter.
Your salary deducting, mother.
Maybe. When the matter will be listed, I will take the hearing. When the matter is called, nobody is coming for the hearing.
Matter is running in the list, mother.
No, running in the list, you wait for your chance term.
Much salary deducting, mother.
When it has been deducted?
50 months selected.
From which month?
May 25, mother.
May 25. Now we are in December. Now there is an urgency.
Other notice, he has imposed penalty.
Till May from December you waited. Now there is an urgency.
Penalty has been imposed, mother. 9 lakh.
Yes. What is the matter?
for extension of interim order, Lordship, it's expiring in the month of November itself.
To be mentioned, extension of interim order 27.
Motion matter, my lord. This matter was made returnable on 25th. Today, my lord. Not happening.
What is the matter about?
My lord, this relates to excise, my lord. My shop.
Okay, it will be given. It will be listed.
New motion. Upon notice.
All notice will be given to my court officer.
New motion.
New motion.
New motion give to my court officer. It will be listed automatically.
This matter, my lord, it will become infractious. If it is not taken up before the 30th of November, my lord. Why, my lord? The central government had specifically directed the state to procure mobile phones and give it to Anganwadi workers. Now, my lord, what the state has done is they have remitted lakhs of rupees into the personal accounts of these workers, asking them to buy these phones contrary to the central government notification by 30th November, and are forcing them to sign a no liability form. My lord, kindly takes it up before, my lord, in end of this week, my lord, I had mentioned it earlier, it is at
Why
item
30th
number
is, why
243.
30th is the
My lord,
last?
they have issued a notification on 17th, my lord, I filed my affidavits and everything, saying that you have to purchase and sign the no liability form by 30th of November. But that is why, my lord, I'm praying for the urgency.
Who will purchase? Worker?
The workers will have to purchase, whereas the central government directs, the state has to procure. My lord, it's a complete violation of the central government direction. And there is a Poshan Abhiyan, my lord, a
Who
scheme
are you?
that I am representing the workers' lordship. They are under immense pressure
So
from all over the
you're
state.
getting the benefit. What?
My lord, I cannot, my lord. If I purchase phones, well, it is contrary to the central government direction. If I purchase those phones, anything goes wrong, that money will be taken from my account. And these are, my lord, poor women across the state. They have no means. The 10,000 rupees has been just simply deposited in their account with the direction they have to purchase these phones. My lord, it's a very short point. Lordship kindly considers that there is a complete violation of the central government diktat. At least till 30th November, I should get the protection, Lordship.
27 को रखो उसको।
May I have your
अर्जेंट मोशन में करो ऊपर। अर्जेंट मोशन ऊपर करो।
May I have your lordships kind leave to mention
We'll actually remove as a director by the ROC. Now, my lord, the ROC has interestingly admitted that it's an error, but we have not rectified the error. My lord, the urgency is this, that it's affecting the operations of the companies that's happening. These things that are beseeching upon the any day convenient. Any day, my lord,
अर्जेंट 4th को रखो अर्जेंट मोशन 4th December।
May I have a lordship can leave to mention? May I have a lordship can leave to mention? Upon notice, I am mentioning, my lord, urgency is this. My lord, urgency is this. Petitioner want to go to abroad for higher studies, but dental council is not giving no objection since matter is pending here. Pleadings are completed. Man, any convenient date.
It is not in the list.
No, my lord.
When your client is going to intending to go abroad?
My lord, end of this year. My lord.
Passport is there.
My lord. Everything
Only
is
for
there.
visa.
Only for visa.
Why?
My lord, for higher study.
Any criminal case is pending.
Criminal cases.
What is the requirement of the no objection from the court if there is no criminal case?
My lord, they ask for no objection from the dental council.
For the?
They ask for for no objection from dental council since there is one complaint is pending before the dental council challenging the complaint. The petitioner filed one matter which is pending. Pleadings are completed. My lord, any day, any convenient.
What is this matter about?
Matter
No
about
objection or with regarding the hearing of your complaint which you made?
no hearing about hearing to the pending before your lordship's court.
So my pleadings completed?
Pleadings are completed.
All?
All, my lord.
Adjourn motion.
The lordships can leave.
Adjourn motion कर दो 3 तारीख को करो adjourn motion.
Your lordships can.
not the online mentioning is concerned, my lord.
What? Electricity matter every day it is coming. What is the urgency? So that's why if you allow the court to go serially, all matters will be taken up. If you are telling that all the matters are urgent, like this only for half an hour mentioning, half an hour adjournment, only 1 hour the court is to be taken up. Every day you are wasting the half an hour court's time for mentioning. If you allow the court to continue with the serially, all the matter will be taken up. But you persons are mentioning every day. But when the case is taken up for hearing, this court didn't find any urgency. Or you will not appear. उसको 4 तारीख को रखो adjourn motion में.
Lordship, we sought for a leave from your lordship.
My lord, this is a matter which is already before my lord, and I have filed an application for being implemented as a respondent. My lord, I am representing the Sugar Manufacturers Association.
So what is the application for? What you want?
Application is for implement to be.
Only application is to be taken up for.
Application may be taken up
For substitution for implementation. उसको application में रखो. Application में रखो.
Matter is at exchange of affidavit stage.
This matter was sought to be, my lord.
Well, this is a new matter. Well, it is not in the list. Or enlisting this matter, this is urgency involved because the property is at stake. Because of the electricity issue, we are not getting any position on any CC from the corporate.
Not in the list.
No, my lord.
Around Friday, my lord. Around Friday, my lord, we sought leave from your lordship. And your lordship was of the opinion that we file the writ petition and then mention. But the urgency is, my lord, hey, a widow lady who is a housewife and her minor son has been made homeless in terms of an order passed by the maintenance tribunal. Now, my lord, there's a simultaneous petitions under the domestic violation is pending, my lord. There's an order of the Honorable Apex Court which says, my lord, if there's a petition under Section 17 of the Domestic Violation Act, my lord, the maintenance tribunal cannot evict a person. But I have been evicted, my lord. I am a widow lady. My husband has passed away. I have a minor son, my lord. I have no place to reside, my lord.
Who has passed an order for eviction?
But the SDO, my lord, under the maintenance tribunal, my lord, 2007 Act, my lord.
Against the widow lady?
Yes, my lord.
For what is the allegation?
The allegation was, my lord, they were, my lord, forcibly, my lord, deciding in the house of the parents, my lord, and my lord, the parents were in a constant state of fear, my lord.
Parent, old lady has been evicted.
No, new, my lord, the
Daughter-in-law.
daughter-in-law.
Tell us like this.
The daughter-in-law, my lord.
Daughter-in-law. So she is not taking care of the mother-in-law. So what the authority will do? That is the only.
But under the Act, my lord, the daughter-in-law does not come within the ambit of the, my lord, definition children, my lord. But the matter is to come tomorrow, my lord, if some precedence is being given.
You can do anything if she is not coming under the person. You can do anything with the mother-in-law.
But my husband was a cancer patient, my lord. The application on a previous occasion was cancelled by the authorities, my lord. None of those facts has been considered, my lord.
4 तारीख को रखो.
I am grateful, my lord.
4 तारीख को रखिए. Urgent motion में.
I am grateful. My lord. 71. Not extremely urgent, your lordship, if it can be taken because it was 60, then it come down to 271. Not extremely urgent. Any date, your lordship.
Readings completed.
No, your lordship. First time, your lordship.
First time.
Item 270.
My lord.
Next week, any date.
Next week, you come on 8 as urgent.
My lord.
उसका 8 urgent motion में करो.
My lord, you passed an order on 4th November to list our matter today, but I am saying there is no writ petition in my.
The file not yet reached to the court. What can be done? File has not yet reached from the department. What the court will do?
No. Today it was supposed to be listed.
Correct. But file is not in the court. How it will be listed? देखो उसका फाइल आएगा तो लिस्ट करते हैं.
Lordship, may I permitted to mention this matter? It is for
Order passed.
for upgradation. Matter. 323.
What is the urgency?
Matter already here before the lordship. Already please count on hearing.
What is the urgency, madam?
During getting the OBC certificate. But
okay, let it come. Let it. Yes.
Lordship, may I?
Well, may I have your lordship's kind leave to mention? Well, very well.
Yes, just.
Yes, madam, I'll wait.
NCLT.
I cannot be given reconnections, I cannot divide the starting traffic. What would make pass the every bottom make a deposit of 20 lakhs before reconnection not
You deposited the amount?
Yes.
28 को रखो अर्जेंट मोशन.
Lordship.
But on these our candidate was appointed.
It will come as a list. That's not.
Lordship, may I permitted to mention?
New motion में रख दो उसको.
Motion.
Yes.
Actually, electricity matter, any day may be fixed.
So motion, all the tick may be taken as
Lordship,
upgradation will not do.
Lordship,
Yes.
this matter is not there in the list. This is
You-
mentioning for inclusion, Lordship.
Yes, call them.
Lordship, I am to mention.
Have your lordship's kind leave to mention, my lord,
All
ma'am.
electricity is there. Yes.
May I have your lordship's kind leave to mention? I'm sorry for my lord mentioning it online, my lord, and not being there before your lordship physically, my lord. Kindly pardons my lord presence. My
Yes,
lord,
yes.
this is a matter, my lord, which I have filed yesterday. My lord, whereby, my lord, the respondents, my lord, I am, my lord, the personal guarantor. My lord, me, my wife, and my lord, son, and my lord, one of the director is, my lord, the personal guarantor. I have, my lord, filed, my lord, the petition against, my lord, the respondents who have filed a section 95 of, my lord, the insolvency and bankruptcy court petition before, my lord, the National Company Law
NCLT.
Tribunal. Yes. And, my lord, interestingly, my lord, the loan account was never declared as NPA, my lord, under the RBI master circular. my lord, there was no subsisting default on the date of issuance or on the filing of section 95. My lord, no invocation of guarantee or demand notices had been given under the 2019 rules also. My lord, the difficulty is under section 97 subsection 5, my lord, that my lord, a resolution professional has to be mandatorily, my lord, appointed on the first date when my lord,
What do you want? What do you want?
An innocuous, my lord, request as well as a difficult request. My lord, if your lordship, my lord, first, my lord, innocuous request, if your lordship, my lord, kindly, my lord, permits me, these petitions are coming up on the 1st of December. If your lordship kindly permits me, my lord, and my lord, if it so commences to your lordship, if your lordship kindly keeps these matters, my lord, this matter, my lord, on my lord 27th or 28th, I've been led by a senior counsel of my lord, the Delhi High Court, Mr. Gopal Jain. My lord, he would, my lord, want to, my lord, come down personally and, my lord, physically do the matter before your lordship.
I don't know because urgent motion all when which will be
understand.
the serially we don't know.
But I understand completely, but Malad,
And if it given in the computer, it will be the serially it will come, not with the latest matter will not come up.
I'll give Malad this the number. Malad, I filed it yesterday. I've got the number. I'll give the number to your lordship's court officers. If your lordship kindly gives me some precedence, because the only difficulty is that Malad, first Malad, the matter comes up before NCLT. A resolution professional will immediately be appointed, and Malad, I'll be Malad thrown into.
Okay, you give where is the case number?
Handed it off.
28.
My lord,
With your lordship's permission, may I mention items?
my lord, this is.
My lord.
May I permit to mention?
I may be permitted to mention a matter for release, my lord. This is a surfacey matter. It has been wrongly listed before. Item 326 of today's list, my lord.
326.
Yes, my lord.
Hello. Who's for the other side?
Moitri Roy, my lord.
It is a surface matter.
Surfacey matter. Yes, my
lord. I'm sorry, my lord. Your lordship has kept it on the 28th, my lord.
Yes, 28.
I'm so grateful to your lordship. So grateful.
The 26, Counsel for the petition submitted. The matter is connected with the Surface Act. Accordingly, press for release of the matter. In view of the submission made by the counsel for the petitioner, WPA 198 of 2025 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
My lord.
With your lordship's permission, my lord, may I mention items 163 and 164, my lord, in your lordship's list today?
Yes.
My lord, these are challenging the bias of the Revocation of West Bengal Incentives Act, my lord. There was a direction passed by this honorable court, my lord, on 20th August for exchange of affidavits. But the last date to file affidavits by the respondents was 10th September. They have still not filed it, my lord. In a similar matter,
I think all the matters are fixed on 14th December or 4th December, something is there.
My lord, in a similar matter which is in the original site, 572 of 2025.
Not original side, in the appellate side, 2-3 matters have been fixed. 4th December, 14th December, I am not aware of this.
My lord, then directions may be passed to the respondents to at least file affidavits in the matter.
Already there is a direction. If they will not file, when the matter will be listed, the matter will be taken up for hearing. No problem. Yes, sir.
Well, the similar matter is already fixed for second for final arguments, my lord.
After a long time, I've got a chance to show my ugly face to your lordships, my lord.
Ayyo.
That is sweet memory, that sweet taste in there. Anyway, my lord, so far item 40 is really urgent, my lord.
At 40? What is the urgency?
The tender, my lord, and they are not yet open, my lord. And the way I have been given, it's not the first time.
When is the date fixed for opening of tender?
22nd. 22nd, but it has not yet been opened. No, it has not yet opened. Not yet opened. So tomorrow, kindly fix it. I will inform the officer. Get that opportunity.
I will fix, but it is already on the urgent motion.
Yeah, 40, I think 40.
It is already in the urgent motion. Please wait today. How far I will go? Then I will see.
And I'll remind you. I'm grateful.
May I permit?
My lord, may I permit to mention one?
May I permit to mention for extension for interim order, my lord, that is expired on my lord.
till when the interim?
November 28, my lord.
Okay, 27 it will listed as to be mentioned for extension.
My lord, may we permit to mention 5 matters, my lord. These are all tender matters, my lord. The financial bid is going to open on 27th. That's why your lordship was kind enough to fix the matters on 26th. My lord, the difficulties, my lord, these are listed as item number 209, 210, 22, 23, and 240, my lord. But only one humble prayer, my lord, let it be kept at the top of the list, my lord, so that
तो कल का लिस्ट में ना अर्जेंट मोशन मिल रही है
grateful, my lord.
May I permitted to mention in this matter for inclusion in the list, lordship?
My lord, application for inclusion.
Give.
Okay, thank you.
Yes, call the list.
My lord, in this matter, my lord.
Come on Thursday.
Let us take matter, my lord.
Okay. Yeah, give the list, it will be listed.
My lord, in this matter, my lord, learned additional advocate general lead this matter behalf of the state, my lord. Item number 1, I am for the petitioner. For not today, my lord. They are not intimated yet, my lord. I have served the additional advocate general, my lord. I have served the notice they have received.
Who is appearing?
I appear on behalf of the corporation and state is the
Additional advocate general, Mr. HON'BLE Sen, my lord, lead this matter with assisting by the
simple
Mr.
matter,
Tuman
my
Dey, my lord.
my lord, this matter already, my lord, has passed one order.
No.
I am just relying upon your lordship on that. It also, Mr. Sen was not there, but his name has been recorded. Identical order, I pray.
My lord, kindly praying for not today. My lord, his
it
my
is
lord
not today,
requested
my lord.
before me, my lord.
Can be
Kindly, I am not
name,
praying for not today. Kindly, my lord.
Tomorrow I will be
Kindly.
in the.
Day after?
No, tomorrow I will be in the Supreme Court.
Okay, my lord, day after tomorrow, my lord. Kindly, my lord.
Your date because they want
My Monday
my lord.
has to be mentioned.
Monday. Recorded.
Well, the similar matter, lordship.
Yes, I understand, but other party wants time.
Yes.
Let
It can be disposed of, man.
as per the submission made by the council for the state.
Receive
Case is adjourned. Let the matter appear on 1st December under the same heading.
Acheta ki, ma'am.
1st December, same heading.
But now he has appeared and he knows that matter will be appeared. Again, he is saying,
My lord,
yes, next.
get him. I
am for the petitioner in this matter. Well, it is a matter, my lord, where the truck of the petitioner loaded with jaggeries, my lord, the good, my lord, you have to eat, that consumable goods of the for human consumption was intercepted by the authorities, my lord, excise department, and ultimately, my lord, the goods were sent for testing to the IFB. My point is very short. In IFB, my lord, I have annexed the report which speak of it. They are alleging that this is a molasses control order. It is a molasses, not the jaggeries. But the IFB has given a report on 15th of September itself. When it was sent on 20th of September, the report has come that your lordship will get it, my lord, wherefrom it will appear that the materials are not the molasses, but it is jaggery. Lordship, their own report will speak of, but subsequently, my lord, they altered it through another. Kindly come to page 77.
Yes.
But this is my goods, which was sent for analysis by IFB Agro Industrial Industries Limited. Kindly come to the bottom portion. I will not take to the complicities in the said column, my lord, where it has been said 77.27. If it is above 50, my lord, it is not a molasses. Below 50 is molasses. Here the report has been given, received all at the bottom, received all the level samples, total in condition with seal ones. As per the analysis, all the samples looks like jaggery instead of molasses. All samples were analyzed as per SSC specification 1152. After this report, whether the authorities can withhold the said goods and the truck, which is in the process of being confiscated by their own notice of 2000 of the month of November. What they have done, it was the truck was intercepted on 15th of September. They sent it for further test, disbelieving the report of the IFB, to another examining body in respect of the goods not identified to us, what they have said. And there they have found these goods are molasses, so they detained me. Kindly come to the next page also. The same day, the other persons, the product was also intercepted
where the, my lord, the IFB report has been accepted. Their own, my lord, wing of testing is IFB. All the reports of IFB, my lord, are the part of your lordship. Your lordship kindly come to page 76, where IFB report has been accepted in 2024. And in my case, when it comes, my lord, not molasses, my lord, they are relying on another report, which they have annexed to their reply to us, my lord. Kindly come to the reply at page 65 on 10th of November 2025 without releasing my truck and the goods. But I have made IFB a party also. Page 65, that is the impugned notice.
Yes.
Well, they say that the materials are found to be molasses. And the report has been annexed at page 79 of another chemical examination team that are 25th September.
So it is sent to the CGM, ACGM, Arambagh.
The matter is
Question is not but it is a question of jurisdiction. Kindly come to the definition of molasses, my lord, has been, my lord, annexed to your lordship's petition, the molasses control order at page 25.
Now, initially there is a report, it is not a molasses, it is like.
So matter is without jurisdiction.
Correct.
You cannot touch it. You have released other tracks and now my track is withheld.
Correct. So now subsequently they received another report which.
My lord, I am on the question, my lord, whether they can have a mind made up to send it for another report when your own organization is giving on 15th of September.
Take all the ground before the magistrate.
They have prosecuted me. They have sent me, my lord, for the purpose of confiscation.
Kindly come to page 65. Kindly come to page 65, regulation order, and forwarded to the London ACGM Arambagh, being CR case number. So it is before that the magistrate is in session with the matter. And you file an application under 457 for release of. If it is not released, you go to the revisional jurisdiction. How the writ go?
We have been criticized. Excise department has been criticized why he was left free. He should have been arrested because it is a non-violable offense. But kindly see
the conduct.
Kindly see the
their own report, my lord, will speak of that this is not a molasses, my lord, and they are already, my lord, running after me. My truck has been confiscated. How they can take the penal action against me?
And Malad, this is not a case in isolation. Past record, the same person has been caught with molasses. This is not the first time.
This is absolutely wrong. I have annexed it.
Malad, same.
I have annexed the document.
Malad, the same vehicle, there is a charge sheet to it.
This is absolutely a cock and bull story. Kindly come to, my lord, their latest position, 22nd of November 2025. They have released my truck because of the IFB report. Found it not molasses. IFB is a party before your lordship. Let IFB file a report to your lordship.
It is a private organization. It's a private level.
It is you have engaged them. It is your organization. You have relied on that report. What a sauce to goose is sauce to gander, my lord. I am also one of the party against whom you are making a different treatment. IFB has been accepted to be a valid organization for your testing, and where the report is in my favor, you are going on prosecuting a particular trader, my lord. On your personal, it appears to be a personal vengeance. Even on, my lord, 22nd of November, they have released me. Can you look at this document? On the basis of IFB report, they have said that no, it is not a molasses. Identical trade, my lord, I am doing it. Only this interception has been made.
Against whom the criminal prosecution is filed?
This concerned person. This person and the driver. And the owner of the vehicle.
Who is Ghosh Bhandar? Who is the Ghosh Bhandar? Received prayer for registration of the case against the Ghosh Bhandar at Shonepur under PS.
That is not our case. That is not our case.
A tender apology is given up.
22nd November report, kindly look at, my lord. And my another consignment has been, yes. IFB के साथ में IFB already received. You cannot discard a report, my lord, this fashion.
এবার ওনাকে ডাক এটাই কি 179 টা হ্যাঁ এটা তো ঘোষ পান্ডারটা কে
Yeah, that is you give that report. You give that report which have been.
Oh, well, it was supplied to Ghosh Banda. That's why Ghosh Banda.
Yes. Just.
And it is referred to the page 65.
So against whom the case was initiated? Gosbanda. Not the transporter and the accused and the driver.
No, my instruction is the petitioner hearing. The case has started against the petitioner.
Where is that? You come with the report tomorrow.
I'll come tomorrow.
An IFB report also be brought. It's a part of the petition, my lord. Let those records be produced before your lordship.
May I try to answer this? Kindly come to the they have annexed. Would find what is the standard percentage that would be there. Page 39. Kindly see. Page 30 is the table.
Yes.
Roman 3.
Yes.
Roman 3 table reducing matter as inverted sugar. Percent by this. This is the minimum. This would be aware. Now kindly see the IFB report itself. It touches it more than this percentage.
Well, that is the second report you have taken.
My learned friend should not interfere when I am submitting. Kindly see, my learned friend is not saying the correct facts. Page 77. Kindly see page 77. This is the IFB's report.
Correct.
Kindly see page 77.
Yes.
Kindly see the percentage is more than that.
Correct.
More than 55. It's a molasses. And thereafter, to ascertain, we have sent it to a government organization. We have sent
very funny submission is being made. Absolutely very funny. False submission is being made.
Please.
Here IFB is saying that it is not a molasses. Above 50, not a molasses.
We are not a shouting competition.
No, now kindly come to the page 77.
Yes,
Page 77, A1, B1, C1, grade 1, 77, 2.
All more than 50%, whatever the percent.
But your authority, how?
It is not my authority. This is one of the organizations
to whom you have sent. To whom you have sent. Now kindly the report. Kindly see the report. Labeled so and so. Looks like a jaggery instead of
it is not an
correct. Looks like a jaggery, not a molasses. Now kindly come to the 78. Now you are relying upon this 78.
No, 78 is not the report of this matter, It is not this report. I am relying on 68.
68.
But 78 is in respect of another person where below 50 is a molasses.
68.
Above 50, not molasses.
58.
58.
Yes, 58. This is the kindly who has given this report? Government Examination Laboratory. Under section 293 of CRPC, these are the expert opinion. We have to send it to them only. Now, would find the contents of the so and so. Last, the total reducing matter as inverted sugar is contents is 52 so and so.
40 to 50
Sir,
or 52. Why you are making it 52? 50. I don't speak anything. I am speaking to your senior. Don't make comments as a junior.
54.25, 52.6 and 50.
So, again, more than 50%, whatever the lowest level. Thereafter, the contents are as so and so. So and so, the range of the total are good release so and so. Now, this has been found to be within the range of a molasses. Now, question is, how can a read code go into this expert opinion? This has to be gone into by a criminal code.
That's why I'm showing. Show me which case has been initiated.
I'll come back with the specific orders where their name is there.
Not name. Whether you have placed the seizure intimation to the London magistrate.
No seizure list has been given to us.
Seizure, because see, if you are seized, correct. You are seized subsequently to ascertain whether it is a molasses or it is jaggery. You send to the concerned authority. First, you send one authority. You are not satisfied. You send to the government approved analysis. You have received the report and you find that it is not a jaggery, it is a molasses. So you have submitted the report. What is the duty of the complainant? What is the duty of the, you have to file a complaint under 202 along with the seizure intimation. So give all the things what you have placed before the London magistrate.
I'll do it.
When? Tomorrow?
কবের মধ্যে কালকের মধ্যে পারবেন একটা দিন সব আছে একটা দিন কালকে পরশু day after tomorrow we'll produce everything.
This court finds that the matter is to be heard only on receipt of the report from the state. Let the report be filed by 27. This is the matter 27 under the same heading.
Let the IFB file a report because they have tested it a lot for all.
Yes, next.
I'm grateful.
All every service we kept on record. I've served upon all respondents.
Item number 3.
Lordship, in item number 3, Lordship, I beg to appear for the petitioner. Lordship, the issue of the writ petition has been settled upon service, Lordship. Lordship, in this matter, the petitioner praying for issuance of fresh admit card. Lordship, admit card for AIB 20 examination. AIB examination. Lordship, after service, they have issued a fresh admit card.
Where is your enrollment? In the Bar Council? Which West Bengal Bar Council?
Lordship,
where is the involvement?
My lord, may I, my lord, issue has been settled. They had a grievance with regard to the admit card that has been issued to them, my lord. Writ petition has become infractuous.
Writ petition has become infractuous.
You received?
Lordship, I have received.
Yes, they have.
Give.
Acha.
Record and all. The London Council for the, you are for the
Bar Council of India, my lord.
Council appearing for the Bar Council of India has submitted that the grievance of the petitioner has been taken care of by the Bar Council of India by issuing a fresh admit card having enrollment number is correct. This is the enrollment having the enrollment number F/1371/1509/2024. Full stop. Counsel for the petition submitted. His grievance has been fulfilled by issuance of the fresh admit card containing the fresh enrollment number. Accordingly, the writ petition has become infractuous. In view of the above, writ petition is dismissed as
my lord, containing the correct name of the candidate, my lord. Grievance was with regard to the name of the candidate.
As well as the correct name as well as the name of the petitioner.
Grateful.
ठीक है? Report submitted. The communication we kept on.
It is 17.
Next.
Are you sure? Chandan, I thought it's 17.
Yes.
But item number 4, I am for the WBACDCL. My initially order was passed, challenging, assailing that order and appeal was preferred. What happened? The petitioner prayed for new electricity connection. Now, in spite of receiving the summons, the private respondent chose not to appear. We were directed to provide connection. We have given the connection. When you have given the connection, another person came and filed an appeal, leave to appeal before the Honorable Division Bench, saying that he was not deliberately, he was not made a party. Now, I have stated before the Honorable Division Bench that we have already by this time given the connection. Now, the Division Bench says very well when you have given the connection. Now, when he's saying that he was not a party, let the Honorable Single Judge decide the matter afresh. But it has been recorded that we have provided the connection. Now, I don't know at whose instance this matter has come up before your Lordship.
Somebody has mentioned, no, that is the problem. Mentioning morning, half an hour, you may say wasting the court of time of the court. When the matter is listed, nobody's. The matter is listed as to be listed under the heading application on the prayer made by the counsel for the petitioner. But when the matter is called, none appears on behalf of the petitioner. No accommodation is sought for. Accordingly, Can 1 of 2025. What about the writ petition already disposed of?
Writ petition has already been disposed of.
Can number 1 of 2025 is dismissed for default.
But possibly this can has been filed by the person who.
Whatever it may be.
Kindly record WCDC is present.
You give your number.
Item number 28.
6. Nobody is there. Call the list. You are appearing.
I am appearing on behalf of the
Item
petition.
56.
My lord, in compliance of your lordship's order in the earlier occasion, I am filing the service lordship.
Yes, I told you, give an specially fixed matter. Why you are not doing this? Yes, who is appearing?
Yes, I am appearing for the state, my lord, as per earlier.
Executive officer.
Yes, my lord.
You are the executive. Why? What is the difficulty? You are much higher than your principal secretary and you are much higher than the principal secretary. Leave aside the court. No, before the West Bengal, State West Bengal, court is nowhere. But you could have been hazarded the order passed by the special secretary. You are not under the special secretary. You are under the special secretary or not? So what is the duty? When you tell me when you pay the amount, when you bring the check, tell me the date. I am fixing on that day.
My pay before the honorable court, I couldn't before
Whatever, I don't know. Now you are the executive officer. There is a direction. You tell me the specific date and time when you bring the check or demand draft or the evidence showing that the amount has been transferred in terms of the order passed by this court, affirmed by the authorities, directed by the authorities.
I am not aware of the I have taken charge.
So when you take the charge, the handing or taking over was not there. This file was not handed over to you. Why?
Actually, my previous executive officer, my previous executive officer.
बोलिए हिंदी में बोलिए कोई प्रॉब्लम नहीं है.
handed over the charge.
हिंदी में बोलिए कोई प्रॉब्लम नहीं है.
I can speak very good.
No, Bengali. Leave aside the Bengali, either English or Hindi.
When I then
When you took the charge?
1st November.
1st November. So how much time you want?
15 days, my lord.
15 days. You tell your exact date. I will fix that matter on the same day, but come with a positive result. Tell your officers also. If you come with any option, this officer, then this court know how the officers is to be bring on before this court. Tell me the exact date when you will come a positive order.
Pehले fixed date.
December.
The executive officer, Bagda Panchayat Samiti, is present in person before this court in terms of the order dated 19/11/2025. He submits that recently on 1st of November 2025 he joined the said post, and as such he requires some time to go through the record and to take appropriate steps for compliance of the orders. In view of this submission made by the executive officer in person, for the interest of justice, the case is adjourned. Let the matter appear on 15th of December at 11 a.m. Call the list.
The restoration application filed by my learned friend, your lordship, on the last occasion yesterday was taken up. As you requested to give me a copy of that, I haven't yet received it.
You didn't like to serve the copy of the application. Have you served?
So my senior is going to washroom. Kindly please take this matter for 5 minutes.
And it takes up tomorrow.
The court is not so harsh, so your advocate had to go to the washroom at the mid of the
Wait,
hearing.
sorry, sir. It's taking a time.
But
All
matter record and kindly take it up tomorrow in the minute, let them serve. And one more thing, the
We went to the GP office for
yes, Durgapur Municipal Corporation is the main answering respondent. They should also be served, madam.
we have already given to this motion.
Take it up tomorrow in the minute, let them serve.
Not today.
All right, yes, sir.
Next.
Sir, please take this copy.
My lord, I had approached your court on the ground of violation of my constitutional right and public law issues element involved in my rented premises. Because if your constitutional rights has been violated and there are certain kind of public law interested, it is Supreme Court direction that High Court can even intervene in the matter of rented accommodation. What is constitutional matter is involved, that I am telling you. What is public law element is
That is subsequent, madam. If required, I will hear you. Tell what is the case about. What the
case is about is that I am having a criminal ongoing cybercrime case is going on with Bandhan Bank for last 4 years in Calcutta High Court. They took my all the SIM in Delhi also, Delhi based SIM they took. What happening with me, with my mother in rented accommodation, we took a rented accommodation in Durgapur. The moment I am trying to put an application or any kind of movement into these two cases, my mother is being threatened by my landlord that you leave the accommodation, despite of the fact we are giving him rent in time at 5 of the month. We are giving advance electricity bill every time, and sometimes there is a severe cut of electricity. We are calling the maintenance people, they are not coming. Then my mother has to call the police station. Then police station is involving the maintenance people. Then they are giving that electricity. This is what happening in a repeated manner for last 1.5 years. We are not in a process to acquire that property. We have no intention to acquire that property. We have two property in Durgapur. One is has come from my my maternal uncle's will. One has come from my father's will. That father's will property, we are supposed to build a home, and the other property we want to dispose of. This is the reason we are staying at Durgapur. Otherwise, we can vacate Durgapur rented premises also. So that other court is having that construction matter which is pending with the NOC of the society. The moment we get the society from the NOC, we will file out. Every time, whenever I'm not peacefully living my life in Delhi, my lord. I stay in Delhi for 20 days. I stay at Durgapur and Kolkata in for 10 days. Here are some cases are pending in Kolkata High Court, which is my personal in my nature. Every time I am coming, I am facing stalking in rented accommodation. I am going outside, I am facing stalking in rented accommodation. What rented accommodation I already left, they are also stalking to the new owner. They are saying others that my mother, she is a 75 years old lady, definitely. She don't have anyone to take care, don't give an accommodation. Where every month I come for 10 days just because my mother is placed here and my mother do not want to leave my father's property in a sale or accommodating to others. Every time the criminal case I want to proceed any case against my previous organization, we are facing harassment in our rented accommodation. And this is what the reason simultaneously I have to involve Durgapur police, which is absolutely.
What the response number 345?
345 is, my lord, this is the
owner of the
yes, my lord. And I have
any further submission?
Yeah, and another submission is that, my lord, in Kolkata, North Chobbish Pargona, South Chobbish Pargona, and Howrah, there is a rent control tribunal of West Bengal government. I involve West Bengal government because if they can put a rent control tribunal in Durgapur, then this case would be much more easily dealt, because they can also have the authority to involve police. So they can also take care of the regularities authorities there, my lord. These two are my humble submission, my lord.
I am for the respondent number 3. My senior is in online.
Huh?
My senior is in online.
Serious in?
Online, sir. Only your lordship.
Lordship, may I permitted to appear online, Lordship. I'm not well, so I'm appearing online, Lordship.
Yes.
Lordship, I'm representing respondent number 3, Lordship. She left my premises in March 2025. Thereafter, we are not having any relation, of any kind of relation. My age is 70. Her mother age is 75. My mother age is also, my age is 70, Lordship. The respondent number 3 is age. There is no one called Muhammad Ali in my family, Lordship, whom she is claiming that he is my son.
The petitioner. the petitioner has filed the writ. Like, after hearing the counsel for the petition and going to the averments in the present writ application, as well as the prayer made in the present writ application, this court finds that the dispute which the petitioner has raised is mainly of the landlord and tenant dispute. Landlord and tenant dispute. Thus, this court cannot interfere, and this court is not having a jurisdiction to entertain the dispute between the landlord and tenant. Accordingly, the writ petition is dismissed. However, the dismissal of the writ petition will not prevent the petitioner for taking appropriate step before the appropriate court of law for her grievances. Yes, next.
My lord, they are already stalking and there are lots of police help is needed because the way they are doing it, my lord.
Go to the civil court and ask the police person. Yes.
But civil court do not have the jurisdiction on public law element, my lord.
Okay.
Civil court cannot direct and police and take control on the crime part. The stalking is inherent, sir.
Who is appearing for the 7?
My lord, I am for the private respondent, my lord.
Petitioner, who is for the petitioner?
My lord, my learned friend, my lord. Yesterday, this matter was moved by my learned friend, my lord. This is the matter relating to, my lord, Shia and Sunni sect marriage register, my lord. And my lord, at the outset, I am submitting before your lordship, subject to correction. My lord, I am inviting your lordship to come at annexure. Case number 31. 31, annexure P8. My lord, this representation was made by the petitioner number 2 through his learned advocate. Kindly see my client, namely Abu Ridwan, my lord. And my lord, the affidavit portion, this petitioner also, my lord, affirmed the affidavit of this writ petition, my lord. He passed away, my lord. My lord, no legal rights of the petitioner number 1 has been infringed. The petitioner number 1's legal right has been in no legal rights of the petitioner number 1 has been infringed by any, my lord, the government authority, my lord. My lord, here he has filed the case for, my lord, circulating some, my lord, leaflet against the petitioner number 1 that he is a Shia Muslim marriage register for the police station Lalgola. This private respondent is the marriage register from Sunni sect of Muslim community, my lord. My lord, what the private respondent, my lord, stated in the leaflet that the Shia sect Muslim marriage register, if he registered any marriage of any Sunni sect Muslims, that is illegal. And that was based on the, my lord, the letter and observation of the district register, my lord. My lord, it is stated in respect of one case of the brother of the petitioner number 2, Rabu.
Who are you?
My lord, I am the marriage register.
Where is your certificate?
My lord?
Where is your certificate for registration?
No, I have not. I am raising the objection against the petitioner. He is registering marriage registration of the persons belong to Sunni sect. Yes, I am the
registered marriage of.
Yes.
Where is your document?
My lord, that has been, my lord.
That is telling.
My lord, that too, my lord, I can produce, my lord. That is not the dispute. I was appointed in the year 2009. My lord, learned friend is admitting.
Consider your prayer.
Yes, my lord. No mandamus. And my lord, the
see the prayer, eh?
Yes, my lord.
You are the respondent number 4.
Yes.
What is the order? What he asked for?
That has not been annexed by him.
That's why I'm saying, show me.
Yes. My lord, that is, my lord, my yes. And the point has been, my lord, taken.
Yes, it is temporary up till the regular incumbent is appointed or up to 30th September.
But that was, my lord, thereafter, my lord, it was extended time to time, my lord.
Where is that?
My lord, then, my lord, I have to come with the affidavit, my lord, on opposition, my lord, my unnecessary petition, my lord. And my lord, my lord, the points taken by my learned friend that he used the date of birth which is recorded in his birth certificate.
Why, sir, we have to go one by one document. By raising this voice,
no,
the court will not be in a position to adjudicate the matter.
My lord, my lord, my lord.
Please, when the matter is being placed before the court, it is the duty of the advocate to make the
That is my lord, my lord,
relevant to the matter.
My lord, my lord.
The court is putting one question, you are discharged. This
My
is only 1997.
Nine.
You are
Thereafter, my lord,
appealing
it
for
was
the private
extended time to
respondent.
time, my lord. I have the
You are
documents.
appealing for the private respondent.
lord.
Yesterday you have taken the time. You
No,
have
no,
not-
no, 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 no. Yesterday, the learned
Okay, whatever it may be, you were there. So, what is your duty? You have to bring all the document before the court.
I will file my by way of an affidavit in opposition to this writ petition, my lord, if required, my lord.
Possibly, my lord, his term has also been extended. Now the difficulty is, my lord, the allegation is this private respondent is spreading rumors about the petitioner, that the marriage registered by the petitioner, who is also a marriage register, it will not be valid for some reason or the other. The competent authority, being the district registrar, had called upon the petitioner as well as the private respondent to come for an adjudication on the issue, since the representation was pending before him. But the petitioner did not appear. My lord, subject to my lord's kind of approval, my lord, if your lordship so desires, my lord, let him, my lord, make a comprehensive representation, because, my lord, there is allegation against the private respondent that he has crossed the age of retirement. Even then, he is continuing with his services, my lord. Lord, if he makes a comprehensive representation, the district registrar will consider everything and pass a reasoned order.
Where is the representation? Have you made?
For justice.
He has not met.
Have you made the representation?
This meeting, I'm not aware, Lordship, it's dated 24th November, I suppose. The representation is at Lordship page.
Where is the page?
Page 31.
That is
Secretary Law Department, Inspector General, District Registrar, Murshidabad. He will consider. District Registrar.
District registrar will
My lord, this representation made by Rabu is the one, my lord, who passed away.
He passed away.
Passed away.
Point number 3. Let him make a fresh representation, comprehensive, blood. When you was alive, I had to come to the court because
Please,
1 year.
এখন কিভাবে proceedings টা আমি বলেছি আমারটা আমি যাব না বলছি না আমি যাব when I made this I had to come to the court because it's not acted upon. I'll go to them again once again, let them give me a hearing. Yes, let them not file a fresh comprehensive representation. I'll do that. We'll consider it. I'll do that. Respondent number 3, my lord, will put in that he'll consider.
Okay.
The arrestment of the district registrar. একদম
The petitioner has filed the present writ application on the ground that the petitioner number 2, now within bracket since deceased, had made a representation to the Secretary Law Department, Inspector General of Registration, as well as the District Registrar Murshidabad, requesting for initiated appropriate inquiry regarding the conduct of the Mohammedan registration within bracket MMR in terms of Rule 10 of the Bengal Mohammedan Marriages and Divorce within 1929, and for taking appropriate steps against the private respondent. During the pendency of the present writ application, the petition number
opposition.
Accordingly, his name has been deleted from the list from the cause title of the present case. Learned counsel appearing for the state submits that on receipt of the complaint from the petitioner, the district, the respondent number 3 had called the private respondent and the petitioner, but the petitioner has not appeared and filed the present writ application. He submits that if the petitioner will make appropriate a comprehensive representation to the respondent number 3, the respondent number 3 will consider the grievance of the petitioner by giving an opportunity of hearing to the petitioner as well as the private respondent. Considering the above, this writ petition is disposed of by directing the petitioner to make a comprehensive representation to the respondent number 3 within a period of 1 week, within a period of a week from date. And if any representation is made by the petitioner from the respondent number 3, shall consider the representation and pass appropriate order by giving an opportunity of hearing to the petitioner as well as the private respondent, all or any other concerned parties who have been affected if any order is passed. The by the above observation that WP
We remain grateful. Grateful. We remain grateful.
My lord, grateful, my lord.
Grateful.
Thank you.
Grateful.
Number 8, my lord, I appear for the petitioner.
Lordship, I am appearing for the Nodia Jela Parishad led by Mr. Amitabh Chaudhary.
Yes.
Lordship,
I have been
Lordship,
without giving an opportunity of hearing.
Report of the respondent for exception there to be filed by petition taken on record. Yes.
Without giving an opportunity of hearing, I have been blacklisted. On last occasion, my lord, when I have mentioned the matter, your lordship told me to go through the Justice UI Chandrachud's judgment in this regard for blacklisting. My lord, I have gone through it and I have bought a copy in this regard also. My lord, it is categorically says that was a case of fraud. This is not a case of fraud. Here also, my lord, opportunity of
hearing
must be given in case of blacklisting.
Debarring the
I
person.
just place the blacklisting order once a judgment. I'll indicate the paragraph at the last. My lord, at page 25 of my writ petition, my lord, kindly see.
Page
25 of my writ.
Yes.
Kindly see. My lord, may I just read it out?
Which clause?
My lord, kindly see, my lord, whereas it has been reported by Sridip Kundu SAE.
Page 27. Page
25. Page 25.
Page 25 is
Writ
this.
petition. No, my writ petition. 25 of the writ petition.
Yes. Yes.
But whereas it has been whereas it has been reported by Sridip Kundu SAE contractual Nodia Jila Parishad that you had physically assaulted him on 4/1/2025. But I indicate, my lord, 4/1/2025 was Saturday, and it was a public holiday. It was a holiday, government holiday, due to the reason better known to you. Whereas a GT has been lodged by Sri Sudip Kundu at Kotwali Police Station, BD number 407, dated 6/1/2025. Whereas the said matter was being discussed at PK OPSS held on 21/7/2025 as per the decision taken in the said meeting. In this question, your agency has to be blacklisted from all kinds of work under Nodia Jela Parishad. Well, directly they issue this one. Well, in this regard, will kindly come to. I would just rely upon the exception which I have taken, the police report. But it is at page 13 of my exception. And I'll just place the rules in this.
Page 13.
13. But kindly see,
Lordship,
the fact of the case is free.
we are appearing for the Jela Parishad, Lordship. We have misplaced our pleadings, copy of the pleadings. So we are paying for not this week, Lordship.
Once the matter is listed as urgent matter, the court will not grant time.
Lordship,
Well, persons are wasting the half an hour time for the
No, no.
mentioning the matter, and in presence of the parties, the matter is listed. Sorry.
Wait me for 1 minute. Mr. Amitabh Chaudhary is appearing in this matter.
Maybe.
He has gone outside Calcutta.
Maybe, no problem, sir. The court is here, the petition is here, brief is here. Sorry, the state government is having so many panel advocates.
Why not, we just need a copy.
Sorry. You file the exception, what the copy is required for the, you file the exception, you file the report, then
We misplaced the brief.
you file the report.
Fine.
No, no. Once I already intimated the bar, once the matter is listed, urgent motion, adjourn motion, and to be mentioned, if the petitions are no, anybody will not appear, the court will take appropriate order. Sorry. Mind it, before this court, this will not, no, no, no. Yes, yes, show me. Where is the exception? Get ready, I am giving 15 minutes time, you get it ready, I am hearing by that time the petition.
Don't have a copy of the PD.
Sorry, sir, you matter is listed to be mentioned every day. The matter is no. This court for this court, no adjournment for adjourn motion and the unlisted the adjourn motion and urgent motion. Sorry. Pay the cost of 50,000. Pay the cost of 50,000. I am adjourning, and as per your choice, and I am staying this as per your choice. I fix the date. Two conditions: pay 50,000. And I will stay the blacklist order, and as per your convenient, whole day I will fix for hearing. A specific date will fix. You want a Sunday, I will fix the Sunday also. I will take the special permission.
Kindly.
No.
Yes.
Can you see the police report? Kindly one. The fact of the case.
Where is the exception? That's the reply. Affidavit reply.
No, it's an exception to the report they have. There was
no.
Resolution for filing of report.
Reports have been
report is there.
And now I am reading on the exception. Exception page 13, the police.
Page 13.
Yes, my exception.
Your exception is not there. I don't think. Affidavit in reply it is mentioned. Page 13. Page 13, yes. Annexer PP1?
Yes.
Yes.
In which no first information report is used.
Where?
Top.
A report for the prosecution in case which no first information reported is used.
No, my lord, taken by the police. So my first mistake is the fact of the case is that one supposed Gona Bharadan Kundu of Ashanagar contractual Nodia Jilla Parishad came to the PS. And inquired into the matter local. Therefore, I believe
Yes.
Payments are not made by the concerned authority.
Yes.
Now, but I will just get a case the rules different department was here were after information the rules here
Yes.
Apply information under right information act of 5 governing procedure for suspension and debarment of guided as procedure for suspension grounds for debarment is very important. As per the memorandum ground others, all submission of all use of substandard or defective failure to comply with the contractual obligations, refusal to accept award or abandonment apply this. The ground by which department because you are trying to complain detection of report verification by the competent authority true of if the offense is proved, suspension department is ordered for a fixed period up to 2 years for the past offense and up to 3 years for repeated offense. Contrary to the fixed of department inside farming, neither in law, nothing will be for 1 year and missing because of their personal there are several payments received from them. For making that they have done this.
Yes.
But the department of clear to getting for my right to life. There are tender floating in that area.
What is the full form of PKOPPS? Kindly come to the page 25 of department on this blacklisting order. Discuss with the OPSS. What is that? PKOPSS. What is this? Who is appearing for the state? You. What is the PKOPSS? Page 25. What is the full form of that? Page 25 of the writ petition. PK. Yes, what is the contention? Jila Parishad. Altercation. Yes.
Assembly such and such was physically assaulted by such and such person, petition number 3 herein, who is also one of the partners of such and such construction work, in the presence of the other partner, namely such and such, who was continuously encouraging the petition number 3 herein during commencement of the said physical assault, because the petitioner agency is illegally demanding certain bill on their own terms from the Nadia Jila Parishad without completing the concerned work, and for this very reason such and such person, petition number 3 herein, in presence of such and such person, assaulted him, and they also hit him multiple times on 4th January 2025 at 1:05 p.m. near such and such place, and the general diary was lodged before the such and such police station for the said physical assault against the petitioner partnership firm by such and such person, my lord. In this regard, it is submitted that the Nadia Jila Parishad by way of memo numbers has issued work order in favor of the such and such company, petition company, for arrangement of drinking water at different schools within Ranagat 2 block in convergence with the Jal Jeevan Mission.
That is obvious.
Yes, they have not completed the work. Kindly page 4, fourth line, Milord. In this context, sentence starts. In this context, it is further submitted that the total number of proposed work were at 36 numbers of schools, but the petitioner partnership have only completed the concerned work at 33 number of schools out of 36, and thereafter, without completing the concerned work, the petitioner partnership illegally demanded completion of work certificate from the Nadia Jila Parishad, and the petitioner agency also illegally demanded for the release of the whole amount of money for the proposed work from the Nadia Jila Parishad. Accordingly, it is submitted since the concerned work has not been completed by the petitioner partnership firm, so it is not possible for the respondent Jila Parishad to prepare first RA and final bills in favor of the petitioner partnership firm. Below, all these documents are annexed below. And my lord, in the opposition they have used, my lord, the documents are annexed. My lord, he would face certain difficulty because his first time my lord is appearing in this matter. That's why he would face some difficulty. It, my lord, B, paragraph B, page 5. It is further submitted at the board meeting of the Nodia Jela Porishad. Purto Kormo Sthai Samiti took place on such and such date.
That is the PKOPVSS.
Porishad Purto Cargo Porimas Sthai Samiti. That I have mentioned before, must be a Sthai Samiti. And in that they have, it was resolved and resolution was taken, my lord. Inter alia, it was resolved and decided to blacklist the petitioner partnership fund for a period of 1 year with effect from such and such period because of the physical assault committed by the petitioners. Yes.
See, only on the basis of the assault, you have blacklisted. The police report says that there is no FIR, no inquiry, only the 135(3). 135(3), you know, want to keep peace. That will run only for 6 months and it will be finished by the subdivision.
Lord, I have with me the police report. If your lordship kindly peruses the police report, your lordship would find. Lord, I have only one copy. Lord, in your lordship's brief, your lordship must have another copy of my report. Lord, kindly see, Lord, this is my copy. This is the police report, Lord. Well, in the office chamber of a government officer, he was physically assaulted.
There is no case under section 332 of the IPC.
Lordship, kindly see my police report.
That's
Kindly see.
It is there. It
Yes.
is only the Chalan 135. They have not initiated any case under 332 of the IPC. No, what is the new BNS?
Well, kindly read my police report. Kindly read my police report. এই একটা দে না পুলিশ তোকে দেওয়া আছে
এক্সেপশনের মধ্যেই তো আছে
কোথায় আছে এক্সেপশন আমায় দিসনি তো Lord, I have not been handed over any exception. তোর মামলা গুলিয়ে দিচ্ছে আমি
কি রেকর্ড আছে যে সবাই পেয়েছে আগের অর্ডারে দেখুন
আমি পেয়েছি কোথায়
Non-FIR prosecution was submitted. The same thing. Non-FIR prosecution was submitted before the court against the so for the under section 126, 135. That no FIR.
So, my lord, let me have a copy of their exception. My lord,
my lord, it was taken on record. I'm giving my copy.
Have a copy, and my lord, I would consult and get back to your lordship, my lord.
Nothing is there. You take appropriate. Blacklisting is not simple, sir. Not simple. Only but there is a complaint and you will blacklist it. Without and your rule says something else. Your rule says something else. How the
they should be given an opportunity.
You are not coming in the morning hours at 10:30. 10:30 to 11, this court is only wasting the time for the mentioning. And keeping in mind of the diary, I am fixing all the times. And now, see, since morning, all the case has been adjourned. Though it is fixed as an urgent motion or to be mentioned. So what is the purpose of mentioning? And the mentioning with the notice. It is not the without the notice.
Yes.
Kindly.
Sorry.
My lord,
Just record an order.
My lord, kindly.
The petitioner has filed.
My lord, kindly.
Sorry, sir.
One opportunity, Lord, so that we can.
What opportunity? Where is the time of the court?
My lord, they have missed the time, my lord. For the ends of justice, kindly gives them not 1 day time. What the ends of justice?
Okay, pay the
They are inviting tenders, my lord.
You are inviting tenders.
Tomorrow you are not
recording. You will allow the petitioner to participate in the tender.
I will come back on Monday, my lord.
Monday, by Monday.
Tomorrow आना, कल के आना.
How many tenders are there by Monday?
Two tenders, my lord. 6/11, the last date is.
I'll come back with
Last date.
You tell me how many tenders is to be issued by Monday.
No, it is not.
That is not the subject matter.
But he will be divided if the matter is.
But if he comes on Friday,
in the face of the record,
if he comes on Thursday or Friday, subject to
second, my lord, is the date for bid submission is the last date submission, my lord. As per their, I have already missed, my lord, multiple number of tenders. But this is 1st December and 2nd December.
Let them give an opportunity, they would come back on tomorrow.
My lord, 1st December and 2nd December is the
Learned counsel for the petitioner has argued the matter. Learned counsel for the state has also concluded his argument. Learned counsel for the Jilla Parishad prays for a day's time. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear tomorrow under the heading urgent motion at the top. It is made clear that no adjournment shall be given on the date fixed. Next.
কালকে পাবো
আমারটা নিয়ে নিন,
তোমারটা আপনারটা দিন, আমি জেরক্স করে আপনাকে দিই।
I am acting for the state respondent.
Lordship, I am appearing on behalf of the petitioners.
কাগজটা নেবেন।
Lord, I am for the WBSCTC.
Yes, who is the petitioner?
I am appearing on behalf of the petitioners.
What is the prayer?
Lordship,
My lord, kindly,
petitioners are the,
my lord, may I permit it to my lord, because earlier.
on last occasion,
Yes,
Justice
there was.
Chondo
My lord, she said,
directed to place a
it's
report.
Xerox from the WhatsApp, your lordship kindly consider.
Respondent number 2.
File a report in response to the allegation made in the writ application.
এটা কিছু না, এটা নেই। The private respondents told us to disconnect the connection, saying that I am the daughter of the original consumer. তো কানেকশন আমি বলে দিচ্ছি।
Who is the petitioner? Arpan.
Lordship, I am appearing on behalf of the petitioners.
The name of
All the petitioners are the present owners.
What is the name of the petitioner?
Petitioner name 1, Achinto Kumar Haldar. Petitioner number 2,
Amit Haldar,
Amit
another
Haldar, and
Arpan.
petitioner number 3,
All
Arpan.
you three wants one connection. Correct?
Yes.
Have you submitted the,
Yes,
to
yes.
give the
My lord, we have no objection to every connection.
What is the last, point 3, point 4?
If they want, we are ready.
Lordship, the main contention is that we are the owners of this property, the property in dispute. Lordship, kindly come to page number 4. Here, paragraph number 4 to 8 demonstrates the background of the predecessor's interest of this particular
What
property.
you want, sir?
Lordship,
What you want? You
the
tell me.
main prayer is the disconnection of the electricity meter which the private respondent number 4 has obtained fraudulently, suppressing the material facts from the electricity
How you
authority.
have been affected? How you have been affected?
Lordship, I am affected because at the time of disconnection, we were not informed, firstly. Secondly, all my movable properties were destroyed by the main and agents of the station manager, who is the private respondent number 3. Thirdly, we are the owners of this particular property, and without
I am disposing of this application in terms of the report. If you want, I will pass an order. They will provide the electrical subject to compliance of the order. With regard to the any damage and all thing, go to the civil court and take care.
Lordship, my only submission is the disconnection of their meter, which has been obtained surreptitiously and fraudulently by the. I am the present owner of this particular property.
Document.
The documents are annexed.
Where show me the document?
Annexure number.
What is why you're not coming directly to the point?
Lordship,
You're
annexed.
going for the Ramayan.
Lordship, annexure P9.
P9. Page number?
Lordship, I'm annexure P6, page 37.
Page 36.
By the virtue of this deed, we are the owners of this particular property.
Page 37.
Page 37.
Yes. You're not bringing the this translated copy? You're relying upon this document, there's no translated copy.
Lordship,
All the court cases are-
this is the gift deed.
Correct, give it, but the contents is dead. You have to come with the.
My lord, I'm appearing on behalf of the private respondents.
Lordship, kindly give a date so that I can place the translated copy. We are the owners of these premises. We are the predecessors in interest are
Who are the private respondents?
private respondents are the trespassers.
My lord, we
They
are
were, while they were the tenants in the year 2008, and after that they are the trespassers. Only for this premise, the trespassers fraudulently, without any valid proof that they are the owner, tenants of this particular portion, they have applied it. And most importantly,
Please, they are in possession of the property.
we are the possession.
They are in possession of the.
They are
Yes, my lord.
currently they are in possession of the property,
ma'am.
and the private respondent number 4 misuses. He's by concealing her own identity, misuses the identity of the respondent number, the mother of petitioner number 2 and 3, who died so earlier.
My lord,
They have private respondent number 4 concealed her own identity, and by placing the identity of the mother of petitioner number 2 and 3 who died far ago, he uses her identity for obtaining the electricity meter. For this reason, I am praying for the disconnection of that particular electricity
Show
meter.
me the document which you are telling that they have split the department like that document, and on the basis
Lordship,
of that
yes.
document, the authorities have provided the electric
Lordship,
connection.
they have
So the document which they have relied upon, and as per your submission, that document is the FOI document.
this is the latest report by the zonal manager, which is not annexed, as it has been given to us after filing this writ petition.
Yes, where is the document? Have you deposited the amount? Query 6. Read the query 6.
Lordship, I have not deposited the amount, but the main thing is that they have admitted.
Correct, sir. So your main case is that they have impersonated before the authority. They are the daughters and they are not the owners, and they got the electric connection. This is your case.
Absolutely.
And you have applied for under the right to information act. Provide the document. What document they have provided to the authority for grant of electric connection? Correct.
That was
Yes. Correct.
Yes, Your Honor.
Now the authority has given the reply to you. Kindly come to the query 6. Query 6 stated that pay rupees 44 rupees for getting the document which they applied for. That the court is asking for you. Which document you relied upon as per your case? That document is the FOI document which they have relied upon and obtained the electricity
Lordship,
connection.
I'm drawing your kind attention to that particular application which has been annexed in page 56, annexure P9.
That document is a false document. I
That
can
is
substantiate.
document, Lordship. They are this 22nd of May 2024. In this particular application, the private respondent number 4 surreptitiously, by concealing her own identity, he is not Suniti Maji. That
he has shown Aadhaar card, he has shown gas booking.
That private respondent number 4, by concealing her own identity and representing and misrepresenting before the electricity department that he is the daughter of the.
That's why you want which document you're relying upon. They have impersonated before the authority. And the first four
This
document.
letter dated 22nd of May.
That is the application.
That is the application in which they have.
Where is the document? What document they have submitted?
They have not produced any legit documents before them.
Query 6. Why you're not understanding? Kindly see the query 6. You're not deposited the amount so that you can get the document from the department.
Lordship, I'm beseeching you to give me some time so that these documents can be
No, you
brought up.
cannot. July, RTI, time is over.
Time is over.
It is July 2025.
My lord, this application is a forged application, my
Just a minute. And sir, your the report which you have filed, that is in consonance of the order passed by this court, 20th June.
Yes.
Satisfy me? Can you see the 20th June and report?
My lord, this is, my lord, 18 July.
20th June. Kindly see the 20th June order.
20th June. Yes, 20th June, my lord. We have directed to submit a report.
What report?
Well, that I have handed over to you.
No,
not that.
file a report in response to the allegation made in the writ application.
Yes, on what basis we have effected?
No, not what basis. Response to the allegation that they have obtained the electric connection by producing the forged document and impersonation.
Yes, that's
so
why-
what document?
Well, that
Produce
we
the
have
document.
indicated, my lord, that Aadhaar card and gas booking card.
So produce that. You produce the total file which you have relied upon.
Well,
The-
that I can produce.
The by an
Lord,
order dated
knows,
20
my lord, if anybody in a settled position in a
That is
No,
different thing.
he's
That's
entitled.
why I asked the question. That is different thing. But you acted upon a forged document, and by impersonation you have given the electric connection. That is a different chapter.
Can be considered, my lord. Whether the document is
By an
forged
order
or
dated
not,
20th
that
June
we shall have to
2025.
They are permitted to inspect the
directed the
premises. We shall have to verify.
WBSCDCL to file a report in response to the allegation made in the writ application. Comma. Full stop. The D and station manager of Ganganagar CCC WBSCDCL filed the report intimating about the 4 points. Full stop. But has not clarified with regard to the allegation of the petitioner. Accordingly, the WBSCDCL is directed to produce the total record in which the proceedings for grant of electric connection was initiated by the WBSCDCL on the prayer made by the private respondent number
4, 5, and 6.
respondent number 4,
No,
5,
only
and
4.
6.
We have given only one.
6 before this honorable court on the next date fix. Before this court on the next date fix.
Well, we have given connection only 4.
Let them 4. Get it in 4.
And 5 and 6 are the son and daughter of 4.
Let the matter appear on 9th of December 2025.
My
presence is recorded, my lord.
9th, I have some difficulties. Either 8th or 10th.
Okay, 8th of December.
Not my
Under same man.
recorded, my lord. I advocate for the statement of my presence.
Not 8th December. I'm grateful to your lordship.
Bring the original record.
Yes. But your lordships kindly consider one thing. If anyone shows the Aadhaar card, my lord, the authority is not in a position to
Not
verify.
the authority. That's why the court wanted. There is allegation.
Yes, we can produce. But the authority
Yes,
is not
next,
supposed
next,
to, my
next,
lord,
next,
verify the Aadhaar card.
That
was very decent.
for the state.
The case of the repetitioner is this, my lord, the petitioner is challenging the resolution dated 20
Actually, appear in virtual mode, my lord.
And my lord, this is the NIT is annexed at page 23 of my petition.
Report filed.
আমি
Report filed.
My lord, on last day I
My lord,
filed the report,
last 2 occasions are there, my lord. The report has not been filed, my lord.
Respondents are directed. You are appearing for.
but I appear for the state. But
Have
if
you
your
filed the
lordship
report?
kindly see, my lord, the order dated এটা কত তারিখের এটা order-টা?
19 September.
19th September, there is an direction to file the
19 September 2025.
On 19th September, my lord, I have filed the report on behalf of respondent number 4
Yes,
to 9.
এটা Mr. Sai appear করছে তো।
Where you filed? On 19 September, there is a direction to submit report.
My lord, they have filed their report.
My
But
lord,
they
on
have filed a
dated
report in
3rd
form
June,
of affidavit.
3rd June, I have submitted a
And my
report
lord, I am to
from the
file an
office of the
exception there too.
superintendent.
No. Affidavit কথা বলেনি তো।
Huh.
No.
Where is the report?
Shall be at liberty to file its so and so report within a week. The report on affidavit, Lord, there is no blood.
No, there is no report on
Direction,
affidavit.
yes.
This is the serial number 2. The respondents are directed to submit a report addressing the issue
My
raised
lord.
in the writ petition.
Mr. Sahi is saying,
My
Lord,
lord,
you have
my-
submitted report.
My lord, on same date, I have submitted the report, but it was not recorded on the order sheet, my lord.
And my learned friend is saying he has accepted the, received the report.
No, I am not
Purani.
saying so.
Report,
My contention.
My report is 3rd June 2025 dated, my lord.
3rd June
2-page
24.
report.
Yes, but the court has passed an order on 19th September. This report is not taken on record. You file a fresh report.
My lord, allow me to file an opposition in this regard, my lord.
opposition.
Because this
But
writ
Lord,
application
prior
is
to
not
that,
maintainable
prior
before
to that,
the
Lord,
court of law.
only, Lord, I
Milord,
want to
in that
draw.
occasion, Milord, in that occasion.
Please.
I want to draw your lordship's kind attention. So far as Mr. Sahi is blood submitted, he shall file a report or your lordship's blood, the prerogative blood, I will not stand in the way. But this, I am appearing for the state blood respond number 1, 2. Blood, your lordship, if your lordship kindly see whether the writ petition, upon perusing the prayer and the supplementary application, whether the writ petition is at all, Lord, your lordship will accept or not. Because of the fact, Lord, he has paid for the
May I press
cancellation,
my petition, Milord?
Yes.
cancellation of the resolution
Yes.
by which the Lord, his prayer, his candidature has been rejected.
Yes.
But Lord, at the same time, he is filed an application, supplementary application, praying for stay of the work order, which was issued in favor of somebody else. But Lord, my respectful submission subject to correction. But the person upon whom the work order has been issued, he should have been made a party before your lordship.
Correct.
Until and unless he is heard, but subject to correction, Lord, whether the natural justice will be served.
May I assist your lordship, Milord?
What you have
My lord, I have to make a small submission before your lordship, my lord.
Milord, this is my writ petition, Milord. Allow me to press my matter, Milord. Till this date, Milord, no work order has been issued from the NIT. As because I am the only, Milord, the lowest tenderer, Milord, that will be appearing from the page 42.
There is no affirmation at all. There is no work order has been.
My lord, one
Milord, that
small
is annexed
submission before your lordship, my lord.
Milord,
My lord, petitioner is relying on
the learned
10
advocate should have allowed me to make my
chairweight in the
submissions,
petition
Milord.
on page number 23.
And
This
Milord,
one is not issued by myself, my lord. This one is not the original one tender, my lord. That's why I pray to file an affidavit before your lordship.
and Milord, then coming to the particular resolution being annexed 4, P4.
P4.
P4 is the Milord, there is resolution.
Page.
Milord, that is at page 43, which is the subject matter of the challenge in the instant writ petition.
Yes.
Milord, the relevant portion is page 44 of my writ petition. The trade line, Milord, the shortfalls of the United Supply Cooperative Society Limited. My lord, got it, Milord? That is the 5th line.
Okay, that's why you are relying. Let them file the report. If the report says that the tender has been issued, the work order has been issued, then you have to take appropriate steps. Let the report come.
Milord, Milord, the matter is already.
By an order dated 19th of September 2025, this court directed the respondents to submit a report addressing the issues raised in the writ petition as well as the CAN 1 of 2025. Learned counsel appearing for the, you are appearing for Mr. Sai?
I'm appearing for 4 to 9, my lord.
Number 4 to 9, submit that on
My
third
lord, till date I have not received the
submitted
CAN
yes,
application, my lord.
report. But this court find that the report is not taken on record.
Accordingly, not taken on record. Accordingly, the respondents are directed to comply with the order dated 19th September 2025 by filing a report within a period of 10 days from date after serving the copy to the General Counsel for the petitioner that the matter appear fully sub. The petitioner is liberty to take exception to the report, if any, please within a week thereafter, please the matter on 15th of December 2020, 16th December 2025 under the same heading.
My lord,
The petitioner to serve me a copy of the CAN application, my lord.
yes, I shall.
The petitioner is directed to serve the CAN application to the respondents by tomorrow.
Only, my lord, I appear for the 1 to 3 state. Lord, your lordship, kindly record my submission. I have taken that point.
Director record that the counsel for the state submitted. The petition has challenged the 10 courses, but the respondents have already issued the work order, and accordingly, third party right has been accrued, and he has not been made as a party to the application. Accordingly, is required to meet the in whose favor work order has been issued. The counsel for the petitioner submission made by the counsel for the petitioner and counsel for the state respondent stating that no work order has been issued. In view of the above, that whether the work order is issued or not will be reflected. In view of the above, the respondents are directed to specify in the report whether any work order is issued or not. If the work order is issued, the name and address of the firm may be specified.
Deeply obliged, my lord.
Let it retain its position, Lord. Deeply.
Retains
position. I'm deeply obliged, Lord.
Deeply obliged, my lord.
My application, may I please your lordship?
Lord, I am for the WBSCTCL authority.
Petitioner made an application for connection of electricity. If your lordship gets at page
Well, to cut the matter, earlier bench directed my learned friends. No, 1 minute. Sir, no, sir, আমি আপনার সাবমিশনটা বলছি না।
If your grievance has been
আপনি করবেন, yes.
Ready to give
Earlier bench directed my learned friends to add party to the East Kolkata Wetland Management Authority, because unless they give us no objection, we are not in a position to effect connections. Whether that has been done or not. Now, apni bolun.
Have you done? Yes, that has been done.
Firstly, what you say has been served. In fact,
Yes, your lordship, you should for EKW I am happy.
Mr. Sonal Singh was but my case is Malad with kindly page 19. That is my application.
19.
Page 19 is my application.
Is the application for new connection?
Yes.
Correct.
Then your lordship kindly turns over to page 24, that is annexure P3. That is my payment of the estimated amount by the WBSB.
24.
Yes, page 24.
Yes.
Annexure P3. Did my lord get it?
Payment.
Yes, my lord. I have made the payment.
4,320.
And when was it made? Your lordship would kindly take note of 11th of February 25.
Correct.
Now, thereafter it was not done. Now, the representation follows at page 25, which is P4. Now, when I moved the matter, they came up and said that this might be wetland. Your lordship gives me 1 minute. My lord, this area where I am seeking my connection, the area is known as Rana Bhutia. My lord, in my which is at page 26. Your lordship would get it.
Village Rana Bhutia.
Yes, Rana Bhutia. Now, I am handing up to my lord the East Calcutta Wetland Manual. They apprehend There's no proof, and I'll show it is cannot be there. Apprehension is absolutely misconceived. Your Lordship would see this is East Calcutta Wetland Manual and table 12.
Your Lordship, Miss Singh is arguing in courtroom number 3. Can
Page 12,
what
your Lordship.
can be granted?
Yes, I will go to the court number 3 and I will hear in the court number 3.
No, Your Lordship, it's not like they just instructed me that.
Yes, that is the resolution of our chief. If the advocate is busy in the other court, the court will go to that court and hear the matter. Yes.
My Lord, could kindly take table 12. Table 12, there are two columns, left hand side and right hand side. Left hand side talks about substantially water body oriented area, and right hand side talks about urban/rural land area. Mine DAG number is 48, and if your Lordship is kind enough to come to 1, 2, 3, 4, 5, 6, sixth line on the right hand side, your Lordship would find 45 to 59, 180. On the right hand side, this column, your Lordship would kindly come to the fifth line.
45 to 59.
ইলেকট্রিসিটি কানেকশন দিতে হবে ওইটা বলছি তুমি দিবে
area. My DAG number is 48.
Where from we get that your DAG number is
here. Only thing your Lordship would pardon me.
DAG number is
48. 48. I'll just give it to my Lord. If my Lord is kind enough to come to page
তুমি তো দিতে পারবে না
31. My Lord, I'm explaining. But I'll just explain, my Lord, what is there. My learned friend would correct me if I am mistaken. My Lord, P1 on the top left hand side is the Moja Rana Bhutia. Then down below, your Lordship finds DAG number 48. That is in Bengali 48. Page P1 on the left hand side down below, your Lordship would find 48. Then your Lordship would find Danga, which is to some extent showing that
ওয়েটল্যান্ড চাইছে সার্টেন করতে ওইখানে
I have shown, my Lord, from the act, the schedule of the act, that the table which clearly says 48 comes within urban and rural area. So the apprehension of WSEB is absolutely contrary to the act and the schedule thereunder. Now, if there is any executive instruction, I go to that part. That cannot override the statutory schedule. Those are my submission. The SEB should immediately take a call on my application and grant me electricity connection.
Yes.
Now led by Larned friends.
I'm appearing on behalf of the East Kolkata
Yeah,
Wetlands.
we are waiting for their
Consent, Your Lordship. EKWMA, Your Lordship. My verbal instruction says that the matter be relegated to the EKWMA. They just want to ascertain in terms of WPA 17901 of 2023, Dr. Shamal Lahiri, which is pending before before a coordinate bench of this Honorable Court, Honorable Justice Amrita Sinha. The matter is next scheduled on the 8th of December, where Your Lordship, many connections were disconnected by the SEDCL and CESC only on the behest that there were no sanction plan and the areas were classified as wetland. Now, and after that, when a CAN application was meant, a temporary connection only to that effect has been given until the demolition is carried out. So my only humble prayer before Your Lordship is that kindly relegate the matter before the EKWMA so that they ascertain whether the property lying is within the wetland management, and even if their connection, most probably if there is not going to be a sanction plan, definitely there is not going to be any electricity connection by the SEDCL as given by, as stated in the order passed by Honorable Justice Amrita Sinha. Though there can be given
a temporary connection which is up to the SETCL. These are only my humble submissions.
Yes, so far our instruction is concerned, it was issued by the chairman cum managing director, where it has been clearly indicated that
Rana Bhutia is
Rana Bhutia is the word.
is
So therefore there is a,
Let me have it.
yes, yes.
Copy.
Dekho.
Now, my lord, this is again contrary to the schedule.
Okay, what I propose, let the East Kolkata
Yes.
Wetland Management file the report, serving the copy to you. This report is
এটা আমি
also
পরে দিচ্ছি
received.
আপনাকে।
You
পরে দিচ্ছি, xerox।
you will also you are also liberty to take exception to the report if required, and I will fix the matter for hearing.
I bow down to your lord.
Yes, yes. So yes, এটা আমাদের
Lieutenant
এটা আমাদের
Consul
একটা
from the
অফিস
East
instruction।
Kolkata
আপনার
Wetland
যদি লাগে
Management
দিয়ে দেবো। আমরা তো
Authority
বইয়ে বলছে আপনার
submit
বানানা
that
বুটিয়া নয়।
You are saying it
a matter
contrary
is
to
pending
this.
to
তাহলে
further
এটা তো
inquiry
এটা চলবেই না তো।
to
কন্ট্রারি
ascertain
তো কখনো এইটা
whether
কখনো এটাকে ওভাররাইড করতে পারে?
সেইটাই তো আমি
তো
বলছি।
বলে দিয়েছেন তো, আমি
It is
জাস্ট বললাম যে এটা আমার ইনস্ট্রাকশন, এটা ওফ, আমি তো আপনার আর্গুমেন্টকে কন্ট্রাডিক্টরি করি।
are situated in the wetland are coming under the East Kolkata Wetland Management Authority. She prays for time to file report. Let the report be filed by
The CTO, Chief Technical Officer, Your Lordship.
the Chief Technical Officer of East Kolkata Wetland Management Authority is directed to file report by 1 week after serving the copy to the London Council for the petitioner. The petitioner is liberty to file exception to the report, if any, along with the report of the WBSCDCL within a week thereafter. This is the matter on 16th of December.
Grateful.
এটা রেখেছি, যদি আপনার কোনো কাজ
My affidavit service of
Affidavit of service be kept with the report.
এটা একটা জেরক্স করি, ওটা দিয়ে দেবো।
I'm grateful to Your Lordship.
Thank you. Next.
Item number 12.
My lord, I am for the petitioner.
But in this matter, my lord, I appear for the Union of India respondent.
Petitioner is a citizen of India. My lord, for his business purpose, and my lord, on the call of the my lord relatives, petitioner with a valid passport, my lord, went to Afghanistan in the year my lord 2019. My lord, kindly remember the worldwide pandemic which lasts for long. For my lord pandemic effect, including my lord personal reason and my lord for health issue, petitioner overstayed therein. With permission of the government therein. Now, my lord, thereafter, petitioner returned on my lord 4th November 2024.
When he
Now,
went,
my-
when he went,
But 2019.
2019 he went and he was there till 2024.
Because my lord, pandemic, my lord, started from 2019 to last, my lord, 3 to 4 years, my lord, kindly consider.
Pandemic started only March 2020, 20th
Yes, my
March.
lord, there was also restriction in my lord traveling one.
Okay, whatever it is
Now,
then.
my lord, on 4th November 2024, my lord, petitioner returned to his, my lord,
4th November
my lord.
2022, 24th November 2022.
24, sorry, my
24.
lord, 4th November 2024.
Correct.
And my lord, at the Netaji Subhash Chandra Airport, my lord, the respondent number 3, that is my lord, the one L Kumar, the assistant foreigners regional registration officer, my lord, interrogated the petitioner. And my lord, without any say, my lord, seized the passport. And my lord, give the impugned, my lord, a certificate or my lord's memo, kindly come to my lord, page 21. Page 21. The surprising thing is that, my lord, the number 1 serial passport number is mentioned. If my lord kindly come to state serial number 6, cause of retention, revoked as per government record. There is no reason, my lord, kindly see. That is my question. Now, my lord, what is the rule? Under which rule the authority can, my lord, revoke or seize my passport? That is necessary. My lord, kindly come. The Passport Act, Section 10, my lord. Kindly see, my lord. What the Passport Act says.
Section?
Section 10, subsection 3. 10.3. My lord, these are the conditions when my passport or passport of anyone can be seized. 10(3)(a). If the passport authority is satisfied that holder of the passport or travel document in wrongful possession, not applicable. If the passport or travel document was obtained in suppression of material information, not applicable. If the passport authority, number C, if the
Have you informed the passport authority you are staying in the Afghanistan?
Yes, my lord. My lord, I have overstayed there, my lord, after paying necessary fines, after getting necessary, my lord.
Correct, no problem.
And
You overstay with the permission of the Afghanistan government
all
or
the documents has been seized, my lord.
whether have you informed the Indian passport authority or Indian embassy that you are overstaying?
Perhaps yes, my lord.
Then
through proper channel.
Then
thereafter, my lord, C, if the passport authority deems it necessary to do in the interest of the sovereignty and integrity of India. Next, my lord, D, if the holder of the passport travel document has at the time after issue passport travel document have been convicted to court, my lord, no criminal case has been pending. If the next, my lord, E, if the proceeding in respect of an offence alleged to have been committed, the holder of the passport, that is also not applicable. F, G, my lord, similar contravents and my lord, fail to comply notice. These are not applicable to me. Now, my lord, kindly come to my lord 10.5. 10.5. Where the passport, may I read, my lord? Where the passport authority make an order varying or cancelling the endorsement on or varying the condition of a passport or travel document under a subsection 1 or an order impounding or revoking a passport or travel document under 3, it shall record in writing a brief statement of reason for making such order. That is my lord. That is my lord point. The passport authority, my lord, without any say, by issuing this impugned memo, my lord, seized my passport without assigning any reason.
So this is now your case only.
Yes, my lord.
Yes. Anything further?
Yes, my lord. That mere administrative action is not necessary to do this kind of order. My
Correct.
lord,
What is the further point? What is the further
and my
point?
lords know very well that Manava Gandhi case on my lord the constitutional bench. This kind of action must be, my lord, with reason.
That's all.
That's why, my lord.
Lord, my instruction is this, Lord, that the petitioner before your lordship is an Afghan national.
Huh?
Afghan national.
Afghan national.
Yes.
Correct.
Lord, he fraudulently obtained the passport in 2018.
Correct.
Thereafter, in 2019, he left for Afghanistan.
Correct.
He overstayed there till 2024.
Correct.
Meanwhile, two notices, as per Lord, the Central Security Agency's report, the passport authority served notices twice upon him for just compliance of natural justice.
When the passport was issued?
Passport was issued in 2018.
2018. When
Yes.
he left for in 2019, he left.
2019 he left.
When you issued the notice?
Notice was issued on 22nd August 2022.
Which address?
In his address as per record.
Passport.
Yes.
Correct.
The notice returned undelivered.
Correct.
He was not found because he was staying there. Now, as per General Security Agency's report, he is a national, Afghan national, and he fraudulently obtained. His actual name, this is very interesting, Abdul Majid Ibrahim Shakil, Ibrahim Shakil. He only recorded his name as Abdul Majid and obtained the passport. This is my written instruction.
So
Twice.
You do one thing, you file the report by way of an affidavit, sending the copy to them.
That can be
Then
done.
you file the reply.
That can be done.
Kindly come to my lord page annexation.
Correct. There is an allegation. Let you file the report, you file the exception if any, then you decide.
Prove my nationality, my lord. All the
Correct.
documents there, I have annexed, my lord.
The counsel for the petitioner has filed the presented application on the allegation that the respondent number, who is the respondent number who has impounded your passport, revoked. Respondent number 3 has illegally revoked the passport of the petitioner without assigning any reason.
All the respondents submit that the passport was issued against the petitioner in favor of the petitioner the year 2018 and in the year 2020 and 19, the petitioner went to Afghanistan and he returned to Afghanistan to India on 4th of November. In the meantime, the authority came to know the petitioner has obtained the passport illegally by suppressing the fact that the petitioner is not an Indian national and he is an Afghani national. It is also alleged that when the authority came to know, the authorities have issued the notice to the petitioner at the address mentioned in the passport, but the same was returned unserved. Consider the submission made by the parties in this court and that the application is to be heard only after filing a report by way of an affidavit by the authority. Let affidavit but report be filed by way of an affidavit within a period of 2 weeks.
3 weeks.
2 weeks.
2 weeks. All
Within
right.
a period of 2 weeks. A reply, if any, there to be filed within a week.
2 weeks.
Within 2 weeks. List the matter on 2 weeks, 4 weeks हो जाएगा फिर तो ठीक है 3 weeks, 2 weeks कर दो 3 weeks, 2 weeks, 6th January.
6th
January.
But a little later there after 6th.
8?
8 already.
8 January.
I'm grateful to her. Extremely grateful.
Next.
I am for the petitioner, Lordship.
This matter, Manad, I have got instruction to appear on behalf of CSC.
You have no instruction.
But
have
Miss
instruction.
Shubhoshri Ghosh was being appointed. Manad, her father is not well. If Madam may kindly take up this matter any day next week.
As Lordship, I have also been informed over the call that her father is ill, Lordship. Lordship, kindly fix the matter on Monday, Lordship.
Let the matter appear on 2nd December.
2nd December, Tuesday, Lordship. Grateful. Under the same heading, Lordship.
Under the same heading.
I am obliged, one.
Next. Yes. What is the prayer?
My Lord, I have prayed that to act, I have prayed with that respondent authorities must act in accordance with law. My Lord, I will explain what is the procedure for this fugitive.
Who are you?
I am in my office, the private respondent used to work. In 2014, my company is in Nigeria. I am an Indian citizen. My company is in Nigeria. In Nigeria, in 2014, an Indian citizen, Asit Ayan Chakravarti, who is private respondent, he joined my office as an accountant.
As an
accountant. And he committed several crimes. He siphoned of the funds of the company. He made backdated dubious bills of supply of the goods and took crores of rupees from my office, and he foisted crores of rupees of my company for shell companies.
So what you are praying before this court?
I am explaining, Your Lordship. Kindly bear with me. Your Lordship, I am praying to External Affairs Minister to take steps against him. I will have to explain the entire law, Your Lordship. What is the procedure for these fugitive criminals? If I am an Indian citizen, the entire offense can be tried in India. And part of the offense has been committed in Nigeria because my company is in Nigeria. He used to work. After that, he fled in India, in Calcutta, and he distributed the entire money to his relatives in India. And he himself purchased the property in India. I have proof.
Is the Indian or national or foreign national?
Indian national.
Indian national. And he fled away from the India to Nigeria.
Yeah, worked. He used to work with me in Nigeria. So now he is in India, in Kolkata. I have proof for that he is in Kolkata. He works in shop boy barrel. So with the sanction of the External Affairs Minister, the case can be transferred from Nigeria to India. The Indian government may request.
Is there any case initiated at the Nigerian?
Yes. Wanted notice has been issued against him. FIR was lodged. Wanted notice has been issued, published in Gazette. May I come to page number 19, Your Lordship? Page number 19, Annexure P4. A wanted notice is there in respect of this. And he has also attempted to kill me in Nigeria. This interim investigation report says, and the Nigerian government itself requested Interpol. It appears from investigation report to take steps against him, to repatriate him. So what is the information with the Indian government? I don't know. But I have come to learn that the Nigerian government requested Indian government to repatriate him. But Indian government has, the law provides that the case can be tried in India, section 188 of Bharatiya Nagrik Suraksha Sanhita Act. May I go through that section? Entire offense can be tried in India, and the case can be transferred if Indian External Affairs Minister requests the Nigerian government to transfer the case to India, and by the time everything happens, he may be provisionally arrested by Kolkata police. This is my prayer.
Yes. But first of all, my lord, there is no extradition treaty between Nigeria and India. But this can only be invoked when there is an extradition treaty.
No, this submission is not correct.
Please hear, madam. Please hear.
Now, my lord, what is the procedure? I'm telling your lordship. First, Nigerian police must issue a warrant of arrest. This has happened in this case. The second step is this, my lord. Nigerian government must submit a report, a formal report to the extradition requesting through the Ministry of External Affairs. Well, we do not know whether any
it is submitted or
yes. Then MEA, Ministry of External Affairs, is satisfied, it forward the report to a competent magistrate to conduct a formal inquiry. Once it is the transfer to the MEA, then if the central government will send to a competent magistrate to having a formal inquiry. Then, if the magistrate satisfied that yes, in this case warrant can be issued, then warrant can be issued by the magistrate himself. Then, the role of the Indian police will come into play. If the warrant is issued by a competent magistrate, then automatically he can be arrested. Once that person is being detained, then the magistrate, he will be produced before that magistrate, and that person has a legal right to defend himself. 6. The magistrate then submit a report after going through the entire record, submit a report to the central government. Then after that, if the government decide to extradite that individual from MEA, coordinate with the Nigerian officials and transfer for the transfer of that person concerned. But this is the entire procedure. So now, we do not know whether any formal request has come from the.
You have made the ministry as a party.
Yes, I have made the ministry as a party, but submissions are erroneous. May I submit? I will show the law. One procedure he is submitting is correct. That there must be a formal request from Nigerian government to Interpol, External Affairs Minister. One part is there. And then the learned friend that central government will request a magistrate, and then under the order of the magistrate, police will arrest him. But here the case is different. He is an Indian citizen. So the entire case, Indian government can take into his hand. I am showing the law, Your Lordship. Section 1
is without the approval of the central government. That cannot be.
No, it is also with the approval of the central government.
That's why without the approval, that's what it's telling. Anyhow, if it is found internal, the ministry find that he is the Indian national, then automatically the report will come. If it is the Indian national, if it is not a foreign national, then again.
No, he is Indian national. I have proof. Aadhaar card xerox of.
You have Aadhaar card xerox,
but he is working there. I have proof.
Authority has to make an inquiry. So report has to be called from the Ministry of Affairs.
May I, sir?
External Affairs, sorry.
So may I show the law that how in
who is appearing for the Union?
But I was appearing for the union.
State, your lordship.
You are for the state.
State.
He is for Union of India.
So you first you submit the report.
But I shall check it up and submit
Yes,
a
you
report.
submit
for
the
your
report.
I
What are the procedure? What are the things?
But
You
the
submit
procedure he is telling is erroneous. I have
Let
some
he
another
submit
part.
the report. Let he submit the report and let it come on record. Then if you telling that that is not correct, then the court will examine that. Then the court will pass appropriate order.
Yeah, I have
directing
law
the
with me.
authorities.
I have law with me.
Your lordship, I have a police report. May I
What report?
submit?
You are already arrested.
No, we had. You kindly sees the third paragraph, your lordship, after reference, sir, and then on 5th August 2022.
Deciding sense.
On 5th August, the line starts.
He was arrested.
Yes,
there.
he was arrested.
They are in Nigeria.
Complaint against respondent number 6 in Nigeria police lodged FIR in this regard. Respondent number 6 was arrested and released on bail by Nigerian police. Thereafter, respondent number 6 absconded. Has lordship got it?
Yes.
Petitioner again lodged complaint on 17th August 2022 before Assistant Inspector General, Nigeria Police Force, to trace out respondent number 6 and bring him back. Several attempts were made to apprehend the respondent number 6 by Nigerian police, but to no effect as reported. And then the paragraph, petitioner alleged that at present respondent number 6 is residing at Nishi Kunja apartment.
No, wanted notice is also there. You are missing that.
See,
That
madam,
is the main part.
I will rely on what the report has come. I have forwarded it before your lordship. If lordship desires, he will direct me. I will do the necessary things. I will do needful activities after that. Kindly seize, your lordship, the report that has fallen from the state police.
You do one thing. This copy of
Yes,
this report,
give me I shall take appropriate.
Yes.
you send to the ministry.
Yes.
And whether the ministry has received any complaint and what steps has been taken. You
And
file
what
the-
steps should be taken?
And what
I shall apprise.
and
give the copy to them. If they satisfied, if they're not satisfied, then the court will pass appropriate order.
My lord, in the meantime, a provisional arrest procedure is there.
Already they have the local police have already taken a step. They have sent the matter to the ministry. Ministry has to respond.
My
that is
Correct.
what I was.
Have you got this report?
no.
I'm handing it over to
Give
her.
the copy.
Yes.
See the second paragraph.
Yes.
That paragraph. They have taken steps, but they cannot directly go and arrest
Yes.
unless there is a case.
Because
Then you will come with another application for violation of article.
already
But this letter, 29th of May 2025, for taking appropriate action. But this letter should be, if it is, it is annexed with them.
Yes.
I shall verify it and.
Yes, you verify it.
And whatever steps will fall next, your lordship, and whatever the directions will be there, we will comply with that.
Correct,
My humble submission is only to that effect.
The petitioner says that the petitioner was the employee of the petitioner at Nigeria, and he has siphoned off several amounts of the company of the petitioner. Accordingly, the petitioner has initiated a case before the Nigerian police, and the Nigerian police has initiated a case against the private respondent, and he was arrested. Subsequently, he was released. Now the private respondent is in India, and a warrant and a wanted notice has also been issued, but no action has been taken for arresting the private respondent and sending the private respondent either to Nigeria or to proceed the case against the private respondent in India.
Yes.
The learned advocate appearing for the state of West Bengal submitted the report wherein it reveals that the state has requested the Secretary Minister of External Affairs and the Interpol of India through the complaint dated 29th May for taking appropriate steps and sending back the private respondent to Nigeria police. But till date, no action has been, no response has been received from the concerned ministry.
Then advocate appearing for the minister for the respondent number 1 and 2 submits that he will take instruction and file report within a period of 2 weeks.
3 weeks.
Within a period of 2 weeks.
My lord, 3 weeks time, my lord, in the meantime, if accused escapes again somewhere,
But
so
the
let there be a provisional arrest. I will show the provision.
Within 3 weeks from date after serving the copy to the London Council for the estate as well as the petitioner. The petitioner is liberty to take exception to the report if any. Please the matter on 17th of December 18th of December 2025 under the same head.
My lord, I'm just inquisitive. I learned from your lordship. May I make a further request to them? Let the case be transferred to India.
That's why let the report come. If the ministry recommends, the matter will be taken by the the Indian government, by the state of West Bengal, automatically. If it's not, then we'll see to that. 18 December, under the same heading.
You will supply me a copy of the procedure.
He has to give me direction first, then I will. Please. Grateful, your lordship.
Deeply obliged.
15 Lordship, I am for the petitioner.
I appear on behalf of
This matter, petitioner Lordship applied for a new electric connection for commercial purpose Lordship for his godown Lordship. Petitioner has obtained trade license from the Kolkata Municipal Corporation. Thereafter applied for the commercial connection before the CSC authority. And by and later dated 17 July, they have rejected my application. Lordship, on the last occasion, the matter was moved before His Lordship Justice Chondo. And Justice Chondo directed the CSC authority to file a report, Lordship.
On the last occasion, we have already put
the report.
Well, we have already filed the
copy of the report I have received, Lordship. I have taken instruction. This is the godown of the petitioner. For that, the KMC has issued the trade license, and for that, I am praying for the commercial connection.
Here, how he is already deriving supply.
Lordship, this is KMC has issued
He
the
knows
trade
it
license.
very well, my lord, according to regulation.
Issued, but the structure.
Lordship, what I am praying, Lordship.
That should be in accordance with the law. So who will take the responsibility in fire hazard in future?
Lordship, Lordship, what I am praying, Lordship, in this matter, goes before the grievance redressal officer. Lordship, kindly refers the matter to the GRO, Lordship.
For what?
For adjudication of the matter, Lordship.
They already submitted the report. What the
Lordship, I am not getting any connection, Lordship.
That's you file the exception, then the court has to decide.
Lordship.
Or you show that no, because as per the guidelines, as per the law, the premises where you want the electric connection, that should be an electrical fitting.
Lordship,
this is in accordance with law.
There is already a block meter and everybody is receiving supply. What will the
No, that is not my name, Lordship. Others' name.
It's the name of the
Lordship, as per section 43, Lordship, I am entitled to get the connection.
Entitled, but you give an undertaking, you made the electric connection intact, and they will inspect the premises, they will satisfy. Yes,
Lordship, they are already deriving supply. Everybody is getting. This is a this is a temporary structure. And Mano will kindly peruse my last paragraph of the report.
In the said premises, Lordship, all the structures are like this, Lordship, and they have issued already connection in others.
No, my lord, we have not.
What is the problem for this?
One of the block, the meters are named in the name of the cousin brothers, my lord. Kindly peruse the report.
Lordship, cousin brother, I have to depend on him to get the connection in my godown, Lordship. I have to depend on a third.
It very well,
I have to depend on a third party to get the connection.
But see the condition of your share.
Lordship, in that locality, Lordship,
court can approve this type of the share electric connection.
In that locality, Lordship, all the godowns are like this, and they have.
I don't know, but this court will not allow in this type of the premises the electric connection can be provided. Who will be responsible for if anything occurred?
All plastic materials are there, man.
You are restoring the plastic materials.
Lordship, I will arrange for the wearing condition of the said.
How can these are all bamboo structures, man? There is no wall. Kindly see the picture.
Lordship,
there is no wall. On wall, they will install the electrical fittings. Where is the wall?
Give me 1 week time for filing the exception, Lordship. I will come.
Kindly see, there is no wall.
Counsel for the petitioner prays for time to file exception to the report.
প্লাস্টিকের উপরে লাগিয়ে দিবি পাগল, এটা দারুণ
Exception
কিন্তু।
filed within a week.
অন্যরা লাগাতে পারে আমার।
9th of
আবার
December. Lordship, 9th of December.
Lordship,
Under the same
under the heading urgent motion.
Yes.
মানে only thing মানে let the copy of the exception we serve
Yes, yes.
beforehand,
Make the copy.
and if we want to file a reply, we'll put in a reply to this.
WBSCTC law. Yes. Yes.
Well, we want to put in a reply to the exception.
That comes first.
As you lordship, please. I'm grateful.
Yes, next.
Lordship, I appear for the petitioner. This is one
In
of the
16 Lordship, I beg to appear on behalf of respondent number 4, Your Lordship. Union.
Yeah,
of
for the
India.
respondent number one. Respondent number one is not properly described. We are a statutory authority, West Bengal Medical Council. They are stating that the state of West Bengal service to the secretary. We do
Secretary,
not have
State
a
of West
secretary
Bengal.
post. We have the register, West Bengal Medical Council. They have to record properly the respondent.
Yes.
Well, the matter is relating to the petitioner sought for direction for the getting the eligibility certificate. He has been qualified from the abroad. He has not much practice as yet in India, unless by the eligibility certificate has not get. So he has made an application before the concerned medical council, but no response as yet. And this is the provision.
What is the law for providing a NOC?
NOC, that is
What is the provisions?
Provisions, the kindly come to GCI, General Medical, kindly come to page 67. Page 67, General Medical Council has given the provisional medical practitioner. And thereafter,
67.
Page 67.
Yes.
This is a provisional certificate for the practice
This
in
General Medical Council.
provision.
This is up to
The 2017 issued on 2nd August 2017. Entry up to the valid for the 2017 issued. Date of issue.
Date of issue is August 2017.
2017.
Correct.
And thereafter, he made a fresh application on page 68 for getting the eligibility certificate. As per the provision of the National Medical Council Act, come to page section 14. He has to make an application, then he will get. Kindly see the.
To whom you have made the application?
This application is the page 68 is the last application is made to the authority. This is not the properly described.
That I'm telling, where is the address?
This is not properly described by the petitioner.
That is the email sent to the National Medical Commission. National Medical Commission was constituted earlier. MCI was there, my lord. National Medical, they made the representation. The student is passed from the Ukraine, my lord. Thereafter, he do not practice in India as regularity needs that. He have to do an internship. Thereafter, he went to UK. There he practiced. He claimed National Medical Commission will give the as per the guidelines of the FMGL rules, foreign medical guidelines licensing, my lord. They have to give the national exit test. They are praying for the national exit test. That is the page 68 they made before the prayer, before the National Medical Commission. If my lord desire, they my lord
I
can
am appearing for the
National
Medical Commission.
National Medical Commission to dispose his application as per
Your
law.
Lordship, I am appearing for them. This is my written instructions on an EC portal. They have to apply for eligibility certificate. That has not been done by the petitioner.
Candidate has not applied the eligibility certificate application through the EC portal.
And secondly, Your Lordship, he has got 50. Why he did not do medical from India? Because he got 50%. He got less than 50% in his science and so that is one of the criteria to be eligible. So he
that you consider.
That is also.
So let he file an application in terms of your this eligibility certificate application through the EC port.
I have given it my written instructions. That is also mentioned.
Let he made an application
in the EC
for grant of the eligibility certificate through the EC portal. And if any application is made through the EC portal, you consider and pass a reason order within 4 weeks.
As you lordship, as you lordship.
There's no question of passing a reasoned order. He'll apply. That will be according to
that you have to decide.
Then a reason order is to be passed. If you are allowing, then there is no question of the petitioner has prayed for the direction upon the authority for issuance of eligibility certificate to appear in the national exit test for enrollment in the state register for medical as medical practitioner. Counsel for the petition submit that. The petitioner has made a representation on 9th of August 2023, but the same has not been considered and is still pending before the concerned authority. Learned Counsel you are appearing for the Medical Council.
2 and 3, Your Lordship.
Learned Counsel appearing for the National Medical Commission.
3 is chairman and 2 is the
Medical Commission and the Chairman, National Medical Commission, and handed over a communication wherein it reveals that the petitioner has not applied for eligibility certificate application through the EC portal. And as such, the request of the petitioner has not been considered. In view of the above, the petitioner is directed to submit an application before the concerned authority. That is to the chairman.
Your Lordship,
It has to be
EC
submitted.
portal means electronic mode
To
portal.
whom?
They have
To address to whom?
There is
Address
the
to chair.
electronic mode portal wherein he has to apply, Your
Petitioner,
Lordship.
petitioner being directed to submit an application through EC portal within a week from date, and if any application is made by the petitioner for grant of eligibility certificate, to appear in the national exit test, the concern of the respondent number 2 will consider. Who will consider?
Your Lordship, 3 will consider. 2 is the
Respondent number 3 shall consider the application of the petitioner within a period of 4 weeks.
Your Lordship.
Within a period of 4 weeks from the date of receipt of the application, and if the authority found that the petitioner is not entitled to get the eligibility certificate, shall pass a speaking and reason order and will communicate the same to the petitioner within 2 weeks thereafter.
Your Lordship, affidavits have not been called for.
As this petition is disposed of at the stage of motion, affidavit has not been called for. Accordingly, the allegation made in the writ application deemed to have been denied. Affidavit of service filed with petition be kept in the record.
Your Lordship, my instructions may be kept on record and that may be mentioned.
Affidavit of service and the instruction filed by the respondent number 2 and 3 be kept.
Sincerely obliged.
I'm so grateful.
Deeply obliged.
Next.
Copy টা ফেরত দিন।
Eta. Yes, next.
Item number 17.
Lord, I appear on behalf of the petitioner.
Sir, I appear on behalf of the Bar Council of India. The respondent numbers 1 to 3, my lord, in this matter.
Yes.
Lord, this relates to Lord, All India Bar Examination 2019, which was held, Lord, in 2024. Now, my lord knows that the format of examination, Lord, is multiple choice questions, Lord, 100 questions, and the time granted is, Lord, 3 hours. So it is, Lord, a test of, Lord, speed, and as much as, Lord, a test of skill and knowledge. Lord, I have to decide as an examinee as to what proportionate amount of time I need to allocate to each question. And Lord, the tendency to answer the first 3 questions right is more. In such view of the matter, Lord, after I give examination, Lord, I find that 7 questions, Lord, have been withdrawn, Lord, to be wrong questions. And explanation of the full marks, Lord, has been done, Lord, to 93, and proportionately, Lord, the benefit of the marks secured by me is given. I fall short by a few decimal, Lord, in qualifying the examination. Lord, I raise, Lord, a few issues. Lord, first, this explanation, Lord, can be a good formula insofar as, Lord, testing the proportionality in subjective time examinations and not in objective type, because Lord, I may not be consistently doing as many wrong questions in the first few, Lord, that I answer. Lord,
there is a negative marks.
There is no negative marking. Lord, so I cannot be a consistent good performer or a consistent bad performer in respect of all the multiple type choice questions. When I fall short of time, Lord, I randomly answer. So that will not be in the scheme of things. it is, if there is a wrong question, it is taking more of my time, my lord, to find out as to what could be a right answer. But if a question is right and I have knowledge, then, my lord, I answer it in no time. So a wrong question is taking more time. My lord, 7 questions, if they have taken, my lord, 2 minutes each, would land me up, my lord, to 14 minutes out of, my lord, 330 minutes. That is 3 hours. That is 180 minutes. My lord, in such view of matter, my lord, when matters, my lord, came before the Honorable Supreme Court as to whether for examinees' fault, examiners' fault, the examinee should suffer or not, my lord, in respect of multiple choice questions, my lord, the Honorable Supreme Court has said, my lord, that if a person being an examinee has attempted the question in multiple choice questions, then he should be allotted full marks. My lord, I first, my lord, show to my...
What is your prayer?
My lord, I am asking for full marks, my lord, 7 marks be given to me in respect...
3 questions.
7 questions.
7 questions. So how many marks have been given to you on that 7 questions? How much marks have been given to you?
My lord, they have allotted me 41 total, and then it has been, my lord, averaged to 43 point something. 45, my lord, is a general pass for general category. So I, my lord, fall short of that fraction of, my lord, marks, my lord. And kindly sees, my lord, my marks would be available at page 25.
You are appearing.
My lord, my lord.
What is the submission? What is stand you have?
My lord, basically, my lord, the petitioner wants grace mark, my lord. My lord, if the learned senior friend can provide the citation which he is relying upon, my lord, I can consider that and come back, my lord. My instructions, if your lordship will kindly come to paragraph 7. Now, what has happened here is, my lord, the pass marks was 45. Now, because of the wrong questions, 7 questions were deducted. So, proportionally, 45 marks, the passing percentage was 45. That was also brought down to 42. Now, this is in respect of all the examinees, my lord. So, there is no discrimination as such, my lord, in respect of particular candidate, my lord. The candidate here, my lord, if your lordship will, may I place paragraph 7, my lord? That your petition states that on publication of the result in the All India Bar Examination, it reflected that 7 questions were struck down and are withdrawn by the authority on account of same being erroneous ones. Therefore, the full marks of the said examination come down to 93, and accordingly, the qualifying marks to pass the same, which stood at 45% of the total marks for the candidates of the general categories, came down to 42% after rounding of the cutoff marks. Then at paragraph 9, my lord, he says, the petitioner above named has acquired 41 in the above named examination. Now, my lord, on his own admission, my lord, he has failed, my lord. Now, he wants grace marks, my lord. Now, this concept of grace marks, my lord, it is not there. This entire matter was placed before the committee, my lord, and it is for all the students, my lord, a common decision has been taken, and the passing marks has been reduced from 45 to 42 on the basis of pro rata.
Correct.
So therefore, my lord, there is no discrimination or there is no nothing wrong, my lord.
What judgment you are relied upon?
Yes, Lord. First thing, Lord, I am not for the moment alleging, my lord, any discrimination. I am saying, my lord, it is unjust, unreasonable, and arbitrary. I am not saying discrimination.
Why arbitrary? If it is 7 marks, 7 marks number has been reduced to 93, and
Yes.
the pass mark is taken to the 45 to 42.
My lord.
What is the wrong in that?
The arbitrariness. My lord, I say this, my lord, is stuck by the logic that the examiner, he presupposes that I would be a consistent performer in respect of the all 7 questions had they been correct.
Correct.
Now, this, my lord, presumption may be correct in respect of subjective examination. But in objective type, where even a random attempt can earn me a mark.
It is correct, but this is not only for you. This is the total batch who had appeared in the said examination. That
Lord, this commission
not only for the one student it has been done. It is for the total students who appeared in the said examination.
Lord, this submission which my learned friend made, Milord, this Milord is resting on discrimination. I am not saying that it is discrimination.
Not discrimination. Here, kindly come to your case itself, the paragraph 7.
Yes, paragraph 7.
Paragraph 7 itself.
My
You
lord.
admit, it was a 93, it was reduced 100 to 93.
Yes.
7 has been reduced.
For everyone.
For everyone.
Yes.
So reduced, so that's why the percentage has also been reduced from 45 to 43.
So I am not alleging any discrimination.
42.
My lord.
So even that after reducing also, you only got the 41% instead of 42%.
Yes.
41% instead of 42%.
Yes.
1 mark is short.
Right. And this is not this is something meted out to all the examinees. I'm not saying it is given to somebody, not given to me. It is not my case.
No, that's why.
And I am saying that this does not qualify on the anvil of reasonableness, because this presupposes that I would be a consistent performer in respect of the withdrawn questions. Now, kindly, my lord, see 23, page 23.
Yes.
Same questions, my lord, are set in 4 different codes, code A, B, C, D. They are jumbled up in a manner, my lord, to avoid copying. Now, my lord, kindly sees, this is code C. Kindly see question number 6, question number 23, question number 45, question number 50.
25.
23.
23. Yes.
Lot 6.
6 withdrawn.
10
withdrawn.
23.
23 withdrawn.
28. I'm sorry. Sorry.
52,
53.
53, and 62, 84.
My lord. Well, these are the 7 questions, which have been withdrawn.
Correct.
Now, these questions, they took up substantial time. Then what was proportionately, I would say, supposed to be given to them. Now, kindly see page 20. That is my answer sheet.
Yes.
This is my answer sheet.
Yes.
Now, my lord would see, I made a representation. Where I have stated page 26 to 33, I need not take my lord to that. I'm only indicating, for the purpose of assisting my lord while my lord is dictating the judgment.
Okay. You file a report.
My lord, if my learned friend can cite the judgment, because my lord, may I hand over one judgment which I have of the Honorable Supreme Court, my lord. Similar issue was, my lord, under Article 32 of the Constitution, it was filed before the Honorable Supreme Court, was dismissed, my lord. May I just hand over? My junior will hand over that, my lord. And there's another judgment of the Honorable Madhya Pradesh High Court deciding the same issue, my lord. Similar issue had arisen, my lord. My lord, the first is the Honorable judgment of the Honorable Supreme Court. My lord, writ petition was filed before the Honorable Supreme Court regarding these grace this was an attempt to take grace marks, and this writ petition was dismissed, my lord.
Lord, I am asking for no grace mark, my lord. My learned friend may insist that I am asking
for
grace mark.
My submission is that these are grace marks.
Now, kindly see this order. Have you got that?
Yes. Lord, my lord is
this order.
Lord, the Honorable Madhya Pradesh.
Yes. Kindly come to the page 2.
My lord.
3rd paragraph.
My lord.
Even we accept the argument the petitioner is alleged to have correctly answered 39 questions, whereas 45 of 93 is 42 questions. Petitioner is on own showing that not obtained 45% of the valid question declared by the Bar Council. Furthermore, we note that the petitioner has participated in exam and not qualified the same according to public interest is the best.
This, my lord, again does not consider that I would be, my lord, a consistent, my lord, performer of either being right or wrong. And the Honorable Supreme Court now finally sees, my lord, this decision. This is reported in 2019, volume 17, Supreme Court cases 725. Lord, kindly sees.
Yes.
Lord, this was in respect of, Lord, multiple choice questions. Lord would kindly directly come to internal page 2 of the judgment. The appellants along with many others, paragraph 2.
Yes.
Many others appeared in UP so-and-so ranker examination for the post of, it is not in dispute that the question paper 18 questions were set in an erroneous manner. The learned judge, being approached by some candidates, writ petition directed that the petitioners who have knocked at the door of High Court shall be granted full marks in respect of 18 questions who have attempted the erroneous questions. Now, kindly sees 4.2. UP so-and-so recruitment and board Lucknow shall scrutinize papers of all candidates, namely the persons who had approached the red court and the candidates who had not approached the red courts. And if they have attempted and answered the 18 questions which were wrongly set out, they will be awarded full marks for the 18 questions. Then 4.3.
But here the question is grant a full mark does not, because the authority has taken that reason, all the persons have accepted that. Now you, after this, you're challenging how it can be.
Milord, I have, Milord, made representation the moment the results were declared.
But here the percentage has been come down. They have taken reduced the percentage, pass mark of the percentage. Here that is not the case before the Supreme Court. Before the Supreme Court, the percent has not been brought down from 45 to 43. Here your percentage has been brought down.
No, kindly see 4.3.
Yes, I've gone through.
4.3 says,
if the candidate not answered any erroneous question, the same shall be reduced. And
yes, kindly pause for a moment.
Yes.
So in respect of a candidate who has not attempted them, he will be assessed on the total number of marks minus the erroneous questions.
Correct.
So in this case, they were assessed on 82.
Correct.
Because 18 questions were wrong. But those who have attempted it, like the petitioner before my lord, to clarify, the candidate shall only get full marks for the questions answered. So this takes into consideration both the eventuality that a person who comes before court says that I have spent disproportionate amount of time on questions, and now that the authorities are saying that we are withdrawing it, how do they factor in the excess time that I have spent? Milord, the Honorable Supreme Court, Milord, has considered and said, yes, the relief is only confined to those candidates who have attempted and not to the others. Now to say, Milord, that the others have accepted, Milord, others have slept over their rights. They may not be, Milord, granted the relief that my Lord would grant me in equity. And again, but Milord, since my Lord, Milord, is sitting, Milord, in a court of equity, I would say those who have not knocked the door of courts should not be, Milord, the victims of injustice by this court, because my Lord is, Milord, invoking, Milord, prerogative writ jurisdiction. Now, prejudice. How are, Milord, the respondent authorities being prejudiced? If what I am seeking, Milord, it commends to my Lord's conscience. This is not, Milord, an examination to a particular post where the number of posts are sanctioned and the persons have already been appointed.
Yes.
What I am seeking only is that if it, Milord, comments to my Lord that I have, Milord, a case, Milord, these marks, Milord, should be assessed on the full 100 marks, and Milord, the 7 marks which are in respect of withdrawn questions should be granted to me. I am, Milord, covered by 4.2 and 4.3 of 2019 Supreme Court.
Okay. My Lord, may I distinguish this judgment, my Lord? Your Lordship will kindly take paragraph 2 of this judgment. My Lord, in this case, my Lord, the Honorable Supreme Court has held that granted full marks in respect of 18 questions who have attempted the said erroneous questions. My Lord, these are perhaps by choice, my Lord. A candidate may have choice which questions he will attempt, my Lord, or the number of questions. Here there is no choice, my Lord. Here the questions are the same for all, my Lord. Here there is no choice that he will attempt or he will not attempt, my Lord. So just to save the discrimination for persons, my Lord, who had attempted the questions, my Lord, which otherwise, my Lord, would have caused discrimination for the persons who had not attempted, my Lord, to bridge that gap. Perhaps this judgment is on that point and there is nothing clear. However, from the facts, it appears, my Lord, that there was a choice of attempting. Here in this examination, there is no choice, my Lord. So therefore, the persons who had attempted should not be prejudiced or should not be, my Lord, brought down.
Any examination, the examinee has a choice to answer or not to answer.
Okay, thank you.
Lord, may I only add this retort? Any examination, the examinee has a choice to answer or not to answer.
In this paper, in this examination, my Lord, there is no choice, my Lord. Grateful, my Lord.
My Lord, 18, if your Lordship could take up tomorrow, my Lord, subject
18.
to my Lord's pleasure. Because 2 p.m. your Lordship has another matter fixed.
2 p.m. matter.
18, my Lord. Tomorrow morning, my Lord.
What is the matter?
My Lord, though it's a small matter, it requires a report and some submission. Lordship kindly takes up tomorrow, my Lord, subject to my Lord's
18 tomorrow. Yes, all the matter come tomorrow, which is not taken, it will come tomorrow.
I'm grateful.
Thank you, thank you.
I already intimated to the bar, if it is listed, application to be mentioned, urgent motion, if nobody, because this all the matter has been listed, only mentioning, not as per the courts. So you're not appearing, what can be done? Yes, call.
Make these elections. Make these elections. I'm appealing for the petition in the matter. This was mentioned by you for fixing. The preliminary challenge which has been raised by my learned friends is on maintainability. That I had started making submission of facts to show as to how the challenge on maintainability, because this is at the
Have you corrected the page number?
Yes, my lord. Yes, my lord. It was an embarrassing situation for me, my lord, on the last day. My lord, today I'll keep it very, very pointed because, my lord, today I need to, my lord, canvas my submissions on the issue of maintainability. It's at the motion stage, my lord. My learned friends have not filed an affidavit yet. My lord, on a very similar issue, but before that, kindly take up my grounds at page 43. I'll indicate what the premise is, my lord. It's a section 13(1) order which is under challenge of FEMA, my lord. What has not been perhaps indicated while taking the point of maintainability is, my lord, this company of which I was an erstwhile director. The company is in liquidation. There was a CIRP proceeding, my lord, and thereafter, presently in liquidation, there's a liquidator. All the documents are, my lord, under the control of the liquidator. The erstwhile promoter has no documents. In a separate proceeding under PMLA, my lord, the bank accounts of the petitioner as an erstwhile director of the company stand attached. Everything is attached. So there's no money which, my lord, is available with the petitioner to prefer an appeal, because if he has to prefer an appeal, he has to, my lord, make that pre-deposit. So onerous burden. With that onerous burden, there is no effective alternative remedy. 1954, I'm carrying that Supreme Court judgment of 5 judges bench, my lord, where this principle was laid down for the first time, and very recently followed in 2021 in a sales tax matter, my lord, where an appeal could not be preferred because there was no money, and 100% pre-deposit would be, my lord, not an effective alternative remedy. So an onerous burden opens up the jurisdiction of this honorable court. It's an onerous burden. Now, my lord, kindly take up the grounds where we have culled out these points.
What is the fees required to be filed in before
But there's a, my lord,
at the time of filing of the appeal?
it's a deposit which is to be made, my lord. The amount of penalty is 200 crores. So any sum which is, my lord, directed to be paid, even if it is 10%, 7.5%, it runs into crores and crores of rupees. The petitioner has nothing to do. And that is why I started with the facts to show what was the genesis of this company. This company, the genesis was not on any bad intention, my lord. The company, the genesis was, it took loan from a consortium of banks. That's why, my lord, those paragraphs which I was reading, I'll quickly take your lordship. But first, I have to, my lord, satisfy your lordship on this preliminary point. And why? And then I'll show, my lord, how there's a jurisdictional error on the very face of the records. But that will be on the merits of the matter. Today, my lord, on the very outset, because the point of maintainability has been raised, 2 points I have, my lord. First, that this is absolute violation of principles of natural justice.
Why?
My lord, the records which are there, which would permit me to give an answer to the authorities, are all with the liquidator. Notice has not been given to the liquidator. The company is in liquidation, my lord. There's a CIRP proceeding which has been initiated way back. So before that, my lord, it was the RP. Thereafter, the liquidator, it's still in liquidation. This stage, what my learned friends perhaps should have indicated, also I don't think they were aware. There's a judgment passed by a coordinate bench of this honorable court, where, my lord, the liquidator had come up, same company, Sri Ganesh Jewellers. Liquidator had come up with a writ petition stating that a proceeding has been initiated
by the officials, authorities under FEMA, the respondents herein, my lord. And this proceeding cannot be continued. There's an attachment which I'm challenging as the liquidator because of the moratorium under section 14 of IBC. The other side took the point that no, the notice was issued prior to the moratorium. CRP happened later. So because the notice was issued prior, you can't take up this point anymore. Notice issued prior, CRP happened later, hence section 14 would not really be a bar. In that proceeding, I'll hand over a copy, give me that copy of the 2025. And this has not been challenged. Milord, it was argued, and that is what I'll rely on before I, Milord, take your lordship to the grounds. This is also a writ petition, Milord, where this point was taken and judgments were, Milord, shown by the petitioner on the interplay between section 238 of the IBC, which has an overriding effect, and all the other statutes, Milord, Electricity Statute, Income Tax Act, Customs Act, separate judgments, Milord, Duncan, and all the, I'm carrying all the judgments, Milord, to indicate that time and again the court has held that this IBC has an overriding effect even in the case of FEMA. And in case of FEMA, my lord, both being special statutes, the one later in time is IBC. That has also been considered. And that will prevail. Hence, my lord, it is, and thereafter it is held that it is immaterial whether the show cause notice, which is the genesis of the entire proceeding, was prior in point of time and the CIRP has happened later, because the language of section 14 is that has been interpreted by the Honorable Court that the language is initiate or proceed with. So you could not have proceeded with. The moment there's a section 14, which is, my lord, after liquidation, it's section 33(5). Same principle, that you cannot proceed unless this is over. And anything done in the interregnum is bad in law. That's exactly what has happened here. There's an exception called out that if there is a proceeding which is happening against an individual who is not the company, then you can proceed, provided the other parameters are satisfied.
So again, here
they may argue that it's an individual.
Correct.
They may argue it's an individual, hence we can proceed. So my first point is, my lord, on the principle of violation of natural justice, because my documents are not with me. All these documents are with the liquidator. So if the documents are with the liquidator, the notice that you have given me, to answer that notice with the documents, I don't have those documents. I can't get it from the liquidator. Liquidator will not give it to me. Hence, it's a sham proceeding. That's taken in the grounds. I'll take your lordship to the grounds. My second point is, if I prefer an appeal, I have to make a pre-deposit. The authorities, it's another arm of the authorities. They are FEMA, my lord.
Yes.
The other arm is PMLA.
Yes.
But PMLA in a proceeding has attached all the bank accounts of this petitioner.
Yes.
So he has no funds to really prefer an appeal.
Yes.
Hence an onerous burden, my lord. It's not an effective alternative remedy. Hence Article 226, my lord, my doors to the Honorable Writ Court is always open. And the third, my lord, all these documents, information which is, my lord, highlighted, lordship will kindly note there's a proceeding which is pending adjudication before this Honorable Court, and it's not disposed of yet.
What was the second point you raised?
The first point is, my lord, that we don't have the documents. Second point, my lord, appeal. The bank accounts are frozen in a PMLA proceeding.
Yes.
So I don't have funds, my lord, to prefer an appeal. Hence, it's an onerous burden on us. And then, my lord, the jurisdictional error, which I'll highlight from section 442, interplay of the reading of these provisions, how, my lord, a person under, there are four provisions, my lord. 442, 37, capital A and 2U, which defines person.
442.
4, section 42,
yes.
Section 37, capital A, section 2, subsection U, and then section 13. This is the base of my challenge, my lord. That's not really on the jurisdiction, that's on the essence, my lord, that today, because that's the merits of the matter, my lord. Today, I do not fall under the definition of 2U qua section 4 and 42. I'll take a lordship to the grounds, that will make it very clear. Before anything, my lord, may I hand over a copy of the judgment I've referred to?
My lord, may I please short pass over Mr. Pathaswati Bhattacharya for the my lord petition, my lord. Can you take my short pass?
Which matter?
Oh, sorry, next matter, sir.
Your lordship will kindly take up at the end of page 1, the first page, my lord, the last 4 lines. While section 14 sorry, of the Insolvency and Bankruptcy Code was applicable once the corporate insolvency resolution process was commenced in respect of any corporate debtor. Section 33(5) of the Insolvency and Bankruptcy Code was applicable once the order of liquidation had been passed by the NCLT. 33(5), my lord, is set out.
Correct.
After that, my lord, over the page, this is internal page 3. Therefore, at the top, my lord, after 3 lines, page 3, my lord, internal page 3. Starts from therefore, my lord. Therefore, the scheme of Insolvency and Bankruptcy Code was that once there was a corporate insolvency resolution process admission, assets would not be subject matter of seizure or attachment. The provisions of sale or approval of resolution plan contemplated under the Insolvency and Bankruptcy Code were such that there could not be a sale to a connected entity. Respondent number 2 had earlier issued a provisional order of attachment under the provisions of PMLA. In respect, my lord, may I pause here for a moment? This is in respect to the same company, my lord, that this order has been, my lord, given by the Honorable Court. So the PMLA proceeding has been referred to. In respect of the assets of Shri Ganesh on April 16, 2019, after an order of liquidation was passed in respect of Shri Ganesh, which was not confirmed and set aside by the adjudicating authority under the Prevention of Money Laundering Act on October 9, 2019. Respondent to appealed against such decision. An order of status quo was passed in the said appeal proceedings on September 20, 2023. The writ petitioner was not concerned with the Prevention of Money Laundering Act orders. They should dissolve upon sale of in view of 32A of the Insolvency Bankruptcy Code. On November 30, writ petitioner was in receipt of the order of seizure, which was issued in respect of the provisions, the issuance of provisional certificate disregard of the moratorium prescribed by 33(5). On January 31, 2023, the writ petitioner was in receipt of petition under 37A2 of the FEMA, seeking confirmation of the provisional seizure order.
Yes.
From respondent number 3, directing him to personally appear in the proceedings. Issuance of the notice was in breach of moratorium imposed by 33(5) of the code. Accordingly, writ petitioner filed the instant writ petition challenging the provisional seizure order and the notice during the pendency of writ petition. The respondent number 3 on May 23, 2023 confirmed the provisional seizure order. I pause here for a moment, my lord. This is indicated because a point was taken by them, which is, my lord, reflected later on in the same order. That since when the writ petition was filed, this was not confirmed, but while the writ petition was continuing, this was confirmed, writ petition becomes infructuous. That has been negated by the Honorable Court. The order dated May 23, 2023 was subject to the result of the writ petition and was a lis pendens event. The order dated 23rd May 2023 was an independent order. Upon the writ petition succeeding, the same would naturally lose its force. The writ petitioner was compelled to file an appeal from the confirmation order dated 23rd May 2023 before the Appellate Tribunal at New Delhi in view of the strict limitation period, which it did, mentioning about the instant writ petition challenging the provisional order of seizure order. Anyhow, this was of no issue when the provisional seizure order was under challenge. Final order passed was subject to the result in the writ petition. Now, we'll have the judgments. In Ramswarup Industries, when during the pendency of a writ petition challenging provisional attachment, the authority issued confirmatory order. The writ petition was not found to be infructuous by this court. The provisional order and the final order were both stayed when the petitioner was found to be entitled to interim reliefs. This is not the point. It was submitted that the provisions of the Insolvency and Bankruptcy Code would override the provisions of FEMA. Therefore, the moratorium under Insolvency and Bankruptcy Code would override the provisions of the Foreign Exchange Management Act. Firstly, the Insolvency and Bankruptcy Code was a later act which was enacted by the legislature when the Foreign Exchange Management Act was already in force. Yes. Secondly, 238 of the Insolvency and Bankruptcy Code clearly stated that the provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect by virtue of such law. When the legislature enacted the Insolvency and Bankruptcy Code, it was conscious of the Foreign Exchange Management Act. On the other hand, the Foreign Exchange Management Act did not have any non-obstant clause. In this connection, reliance was placed on the following judgments. First is Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat. Honorable Supreme Court held 238 would override provisions of the Electricity Act. Yes. The second decision, my lord, is Sundaresh Bhatt versus ABG Shipyard. Sundaresh Bhatt, liquidator of ABG Shipyard versus Central Board of Indirect Taxes. Here, my lord, 238 would override Customs Act. Third, Duncan's, where, my lord, T Act, Section 16G of T Act would be overridden by the IBC. Innovative, my lord, that IBC would override Maharashtra Relief Undertaking Special Provisions Act. Over the page, my lord, Monet Ispat, Supreme Court held, this would override Income Tax Act. Yes. An assistant director, it's an NCLT decision. And this is an NCLT decision where this is only indicated. So, my lord, here it states moratorium under 14 was applicable to proceedings under FEMA. But it's NCLT decision. And then Directorate could not proceed against the corporate debtor as long as moratorium was there. If under provisions of Foreign Exchange Management Act, if any directors, kindly mark this, this is perhaps what they'll try to indicate. Yes. Directors, officials were individually liable for any action done prior to the commencement of the corporate insolvency resolution process. Applicant might proceed against these directors of the corporate. I pause here for a moment. In the previous decision of the Supreme Court, my lord, which has been referred to in this judgment, it has already been held that if there is a notice given, which is a commencement of proceeding, my lord, prior to the CIRP, that also cannot continue.
No, but you are the individual.
Individual. Well, this is an NCLT decision. Correct. Supreme Court in the previous decision, my lord, in Ramswarup Industries, has held that even if there is a notice given prior to, my lord, inception of CIRP, correct, notice to an individual also, correct, it can't proceed. And I'll indicate that. That's one of my many grounds, my lord, why writ is maintainable. Give Ramswarup Industries.
Yes, next.
And my lord, I'm carrying all these judgments and hand over, my lord, all the copies of the judgments. Now, my lord, thereafter, the submissions of the other side is recorded in paragraph 3. And your lordship will find the findings of the court from paragraph 4. It's internal page 8, my lord.
Yes.
Paragraph 5, actually. Admittedly, the corporate insolvency resolution process for Sri Ganesh commenced, my lord, kindly mark the date. It commenced on 12th February 2018. Same, my lord. This is the company. Pursuant to an order passed by NCLT at Kolkata, under the provisions of the Insolvency and Bankruptcy Code, Section 14 of the Insolvency and Bankruptcy Code prohibits the initiation of suits or continuation of pending suits or proceedings against the corporate debtor following the initiation of the corporate insolvency resolution process. On September 14, 2018, the National Company Law Tribunal directed that Sri Ganesh should be liquidated. You kindly note the date. It's also in 2018. Incidentally, the proceeding against the corporate debtor accused under the FEMA was initiated on November 15, 2016. That is why that point was taken by them. This was earlier in point in time. The mere fact that the proceeding under FEMA was initiated in 2016 before Section 14 of the Insolvency and Bankruptcy Code came into operation in 2018 would be irrelevant. Kindly mark this, my lord. As Section 14 speaks not only about the initiation but also about the continuation of pending suits or proceedings. This is what, my lord, I had submitted. That today it is immaterial whether it has happened prior in point in time, my lord. Once an order of liquidation was passed, as in the instant case, Section 33(5) provides that subject to Section 52, when a liquidation order has been passed, no suit or other legal proceeding shall be instituted by the liquidator on behalf of the corporate debtor with the prior approval of the adjudicating authority. As has been rightly contended on behalf of the petitioner, what was contemplated in a corporate insolvency resolution process was the approval of a resolution plan. After liquidation order, the corporate debtor might be sold as a going concern or the assets might be sold. Therefore, once the corporate insolvency resolution process was admitted, assets of the corporate debtor could not be attached. They would be sold in the corporate insolvency resolution process or in liquidation. 32A of the code provides over the page for more. According to it, no action will be taken against the property of the corporate debtor in relation to any offense committed prior to the commencement of the corporate insolvency resolution process. While the Prevention of Money Laundering Act came into force in 2002, IBC came into existence in 2016. Ramswarup Industries Honorable Supreme Court held that the provisions of the IBC would override the provisions of FEMA. Therefore, the moratorium under the Insolvency and Bankruptcy Code would override the provisions of FEMA. Not only was the Insolvency and Bankruptcy Code enacted while FEMA was in existence, but Section 238 of IBC also clearly provided for a non-obstant clause. On the other hand, FEMA did not have such a clause. In this regard, reliance was placed on behalf of the petitioner on all the judgments are quoted, my lord.
Yes.
Where the Insolvency and Bankruptcy Code was permitted to override the corresponding provisions of these acts. And then it is discussed individually, my lord. Paragraph 11, my lord, the NCLT decision has been considered. The last line, if any of the directors or officers were individually liable for any action done prior to the commencement of the CIRP, the applicant might proceed against those directors or officers. That's the finding of the court. Now, what is to be seen in this particular writ petition is, my lord, on the merits, whether this could at all have been done, because my challenge is to the jurisdiction. My challenge is to the interpretation of Section 2U, which defines person. Qua, my lord, Section 4, Section 42, Section 37A, and finally Section 13 of the FEMA Act. Jurisdiction of these authorities. That these authorities do not have jurisdiction to proceed against the petitioner in any manner, because the petitioner does not fall within the ambit of the structure of the Act under which they have sought to proceed.
Yes.
Paragraph 12, my lord, as was contended on behalf of the petitioners, issuance of provisional seizure order was in disregard of the moratorium prescribed in 33(5) of the IBC. So was the issuance of the notice. It was further contended that during the pendency of the writ petition, respondent number 3 on May 23, 2023 confirmed the provisional seizure order. Therefore, the order dated May 23, 2023 was subject to the result of the writ petition. The petitioner has sought to explain the reason for filing of the appeal before the appellate tribunal, stating that the same was in view of the applicable limitation period. So here in this case, my lord, an appeal was already preferred. Even then the Honorable Court considered the writ petition, because that point was taken by them. That you have preferred an appeal, how can now you proceed with the writ petition? It is to save limitation as an abundant caution that filed the appeal. That was the explanation accepted by the Honorable Court. And that is why the writ petition is entertained. As has been held by the Honorable Apex Court in catena of judgments, decisions, provision of IBC would override provisions of other acts, like Foreign Exchange Management Act 238 is strongly worded indeed. In view of the proceedings pending under the IBC and the other orders passed therein, the impugned provisional seizure order and the impugned notices could not have been issued. Therefore, the impugned notices are quashed. However, proceeding can fairly be initiated against the erstwhile director and the officer of the corporate debtor if they are found to be individually liable. If they are found to be individually liable. That's the subject matter of this writ. Whether they can really proceed against this petitioner.
So here is categorically stated, the impugn notice are caused, the proceeding can fairly initiated against the erstwhile director.
My lord. And these proceedings which I am, my lord, challenging in this writ petition is the erstwhile, my lord, notice. It's not pursuant to the leave given by the court in this proceeding. This is April 2025.
Correct.
Your lordship will kindly see, this is April 16, 2025. And what I have challenged, if your lordship comes to the press, these are all, my lord, notices prior there to. It's not that.
So what is the leave this one? Therefore, the impugn notice are caused and however the proceeding can fairly.
They have not started anything. They have not initiated anything. So, my lord, this, kindly see page 70. The press, it's March 27, 2024. That is the order which we are challenging. The order dated March 27, 2024.
Yes.
So not pursuant to this direction and leave given by the Honorable Court. Now, my lord, kindly take up the grounds first. Today, my lord, my endeavor is to, my lord, meet the challenge of maintainability. That I will show, my lord, that this is absolutely, my lord, maintainable before this Honorable Court for reasons which I'll quickly, my lord, indicate from the grounds. I will not, my lord, trouble your lordship any further. And two judgments, my lord, I'll place reliance on the basic premise, my lord, that if it's an onerous burden, and if there's violation of principles of natural justice, this Honorable Court always has the power, my lord, to entertain a writ petition. Your lordship will kindly take up page 43.
Yes.
That's where the grounds start.
Yes.
Page 43, my lord, Roman 3. For that, the bank accounts of the petitioner having been frozen or seized by the Enforcement Directorate in the proceeding initiated against the petitioner under the Prevention of Money Laundering Act 2002. And as such, the petitioner has no option of preferring an appeal against the impugned order before the appellate authority for foreign exchange at New Delhi. Since the amount of penalty imposed cannot be deposited by the petitioner in view of the facts that the bank account of the petitioner have been frozen by the authorities, which is another arm of the respondent authorities. And it is untenable how one authority, knowing fully well that the bank accounts of the petitioners stand frozen, can direct the petitioner to file an appeal if agreed by the order passed by the said authorities. No other condition, if imposed by the appellate tribunal, can also be fulfilled by the petitioner, since its properties are also attached, and as such, there is no effective and alternative remedy available to the petitioner.
May I take your lordships kindly for another matter?
Yes,
My
yes.
junior is here, he is taking note.
Thereafter, my lord, ground 4. For that the petitioner has no other alternative remedy and efficacious remedy. And as such, Honorable Court has jurisdiction to adjudicate the issues raised in the present petition. We are thereafter kindly see Roman 5. Issued a notice of July 6, 2020. May I pause here for a moment? This order is a culmination of two notices, my lord. One notice of
But
July.
how you can say the petitioner has no other alternative to have a alternative and efficacious remedy?
My lord, because your lordship will kindly see in clear violation, the last line of that ground, clear violation of principles of natural justice and is perverse. That's because, my lord, I do not have copies of these documents, and that is, my lord, my ground number 8. I'll come to that. My ground number 8, where I've said that all these documents are with the liquidator. Whatever you have asked.
That's correct, but no alternative efficacious. You are not able to file the appeal.
That's my lord, because I'm relying on those judgments where, my lord, it is, if it is not a clear alternative remedy to me, my lord, it creates a burden on me as the petitioner, then that will not be the only remedy. It will not be the alternative.
That's correct. That you are not able to.
I'm not able to
avail the.
Hence, my lord, onerous burden.
Indeed. As per the.
Indeed. Hence, not an efficacious remedy. Alternative remedy, but not an efficacious remedy. Only to draw that distinction.
Okay.
Lordship will then kindly take up ground number 5. This is, my lord, there are two notices which have culminated in this order, my lord. One is July 6, 2020 and one is December 12, 2023. Registration of complaints against the entities, including the petitioner, containing a sum of 72 crores. 7220 crores. 7220 crores remained outstanding and was required to be realized in respect of the exports by the company. And the respondents have recorded in para 1.23 of the order impugned that the petitioner had appeared and had contended that the petitioner had requested the banks to set off the accounts outstanding amount, and the request was not accepted by the bank, nor was it reported to RBI. If this was accepted, it would have mitigated the damages, the losses. We have taken steps. That's, my lord, ground number 6. Ground number 7. There is another writ petition which is pending adjudication on the attachment, my lord. That's ground number 7, which is still pending adjudication, 18579 of 2023, my lord.
Yes.
Ground number 8. This is important, my lord. Kindly see. We have requested the respondent authorities as recorded in para 3.9.8 of the order impugned for documents and information which would form a vital part of the evidence to be relied upon in support of the contention that the petitioner and to call upon the official liquidator of the company Sri Ganesh Jewellery House India Limited and or the concerned DRI enforcement branch authorities for providing the records or documents and information, since the company was in liquidation and the liquidator was in control of the said documents, and without the same, the petitioner could not make any effective representation, and the same would be in violation of principles of natural justice.
So this
Sham discharge of such principles.
This is a main.
This is my main ground. And without granting fair opportunity, that's, my lord, Roman 9, where we say that this is a sham opportunity given because the documents are not there. But thereafter, ground number 11. Now here, my lord, it starts ground number 11 onwards. I do not know whether I should make the submission today, because ground number 11 onwards is on the interpretation of these provisions. All explain, my lord. I will, if your lordship permits me, I'll quickly take your lordship through as to why is it that we are contending in the writ petition that they don't have jurisdiction. But that's on the merits. I'll have to indicate, and I'll quickly indicate that, my lord, as to what is the interplay, why I'm not a person under 2U satisfying the ingredients of section 442 with the attachment ingredients of the 37A and, my lord, section 13. That interplay, my lord, but that do I enter into today, my lord, or should I, my lord, first the maintainability point, or would your lordship hear it together?
Let the Q answer.
On the maintainability point, my lord, because this is my other challenge. My main challenge is also that they don't have jurisdiction. If it's a jurisdictional challenge, then, my lord, the honorable court always
cited the judgment. Let the Q reply on that.
My lord, may I also quickly, my lord, before this is on the only on the point of maintainability.
Correct.
What are you giving?
Or otherwise you continue just complete your submission on merit also. I will decide that accordingly.
Very well.
That will be better.
My lord, should I first, on that point of, my lord, onerous burden, may I hand over the classic decision of Himmatlal Harilal Mehta, my lord, 5 judges bench, stellar composition, my lord. Justice Mahajan, Chief Justice, B.K. Mukherjee, S.R. Das, Vivian Bose, and Justice Hassan. 5 judges bench. This is, my lord, where
It's still following.
yes, my lord, still followed in 1954, my lord. And very, very brief. Paragraph 9. Actually, 8 and 9.
Yes.
And paragraph 10 also, my lord, 2020. And the recent decision, my lord, the division bench judgment, my lord. A provisional attachment in GST. Principles are reiterated. Paragraph 27 is where, my lord, the principles are called out. This is internal, my lord, this is running page 795, top right hand corner.
Yes.
The paragraph 27, 27.1 to 28 minutes. (27.3) Exceptions to the rule. We have A fulfilled, B fulfilled, C fulfilled. A is, my lord, for enforcement of a fundamental right. B, violation of principles of natural justice. C, wholly without jurisdiction. That's our contention. 27.6 goes on to say, even if there's a disputed question of fact, usually don't interfere, but still if you want, you can.
Objectively.
Yes. And 28, quick reference to all the other, my lord, judgments which are followed. And here, my lord, it was a burden, hence the High Court had dismissed the petition, and the writ petition here, my lord, was allowed. That's paragraph 78, the last page, my lord.
Provisional attachment cost.
My lord. Yes. I'll not multiply the judgments, only these two, my lord, on the point of maintainability. Now, my lord, the provisions, may I quickly, my lord, indicate from the grounds the interplay as to why, my lord, we are submitting what we are submitting. That will give a context, my lord. You kindly take up the act along with, my lord. But I'll be taking up some time, my lord. That's the difficulty, because all these provisions, I'll have to take your lordship through this. That will take us some time, my lord.
How much?
Lord, an hour, my lord.
Today you will not be able to, because 3 p.m. the original side matter is
No,
there.
my lord. Should I start, my lord, on a day where, my lord, I can actually take your lordship through the entire thing in one go?
That will be better.
Yes, my lord.
You will take 1 hour.
I may take 1 hour.
They will take 1 hour.
This is at the interlocutory stage because, my lord, I'll be praying for that interim relief in the
Problem
matter.
is the time.
I understand that, my lord. I understand that completely.
एक कौन सा डेट खाली है फिक्सिंग के लिए?
But I know till 8th there is no chance because morning your lordship was pleased to fix that matter, my lord, on 8th. Doctor's choice, which I mentioned, my lord. So
because other motion is not taken, then
My
it
lord.
is difficult.
Lordship.
All the advocates are urgent motion. हैं? वो तभी फिक्स किया ना सुबह 2 बजे 2 बजे फिक्स किया ना 2 बजे ऑलरेडी 2 है, 2 बजे। हाँ हाँ, वो ठीक। फिक्स मैटर मतलब टाइम है, टाइम नहीं, टाइम के लिए मुझे चाहिए। 2 बजे का कोई और है? देख, 9 तारीख, 9-10 नहीं है। ये सब क्या फिक्स मैटर? अर्जेंट मोशन है, अर्जेंट मोशन। ठीक है, 9 तारीख को रख दो। 9th, 9th।
Very deeply obliged.
Counsel for the petitioner has argued the matter on the point of mentability, and he intended to argue the matter on facts, but due to paucity of time, hearing could not be completed. According to cases adjourned, let the matter appear on 9th December at 2 p.m.
Deeply obliged.
Excuse my impertinence, my lord. Excuse my impertinence. Excuse my impertinence to remind your lordships, my lord. My lord, assure me if it is not it, mention it. Kindly fix it on tomorrow, my lord.
Which one?
40.
40.
There's no chance to reach.
How much time will it take? It will
I'll take at least 1 hour. I'm saying I am very precise as my lord knows me, my lord. I always try to go to the root of this.
Yes.
So kindly fix it tomorrow at 2 p.m. My lord. I'll inform the other side.
So 2 p.m. already fixed, है ना?
Then দাও তো কথা বলুন কালকে লিস্টটা দেখান জাজ সাহেবকে otherwise my lord ultimately it will infructuous because the way they are dealing me my lord is surprised my lord without any so cause anything reject sorry I'm extremely sorry my lord for your loss in income.
The duty of the advocate.
I'm grateful because you are from the bar, that's why.
Friday रख लो, Friday है कोई नहीं है, 2 बजे नहीं है। 28
my lord
28 Friday.
Well, only in the meantime, my lord, last date for filing up submitting that is gone. I have submitted.
When?
That is, I've done it.
Oh.
Now they are trying to open because I am very much. That's why. Kindly accommodate me, my lord. I will not take. Now I reduce my time. 30 minutes.
No, it's okay. No, you take your time. एक काम करो, 26 कल 26 है ना, कल 12 बजे, 27 को 12 बजे है, देखो 27 12 p.m.
As well, I'm grateful. 27
at 12 noon is there. 27 at 12 noon. 27 at 12.
I'm grateful, my lord. Sorry to disturb your lordship. Normally, I'm not getting chance.
Don't tell sorry.
But whenever I get a chance, I must come. I may lose, I may win.
So that's why I'm telling it is the duty of the advocate to get a chance to argue the matter, so the matter can be disposed of.
I'm deeply obliged. May I leave, my lord?
So because when I was that side, I try my level best so the matter can be disposed, so that I can get the new matter.
Oh, the golden time. So may I leave, my lord?
Thank you.
40. भूले जाओ ना भाई.
40. Item number 40.
May I beg to mention one matter, my lord? My item number is 20. My lord, it is coming in the list, but for 10 days, my lord, this is not happening, my lord. My lord,
Let 20 minutes there. I am calling the list. If you will find the time, it will be taken.
if it is not done, my lord, any time in the week,
Tomorrow
my
it
lord.
will come.
Lordship.
Today it will not. Tomorrow it will come. The list continue.
Lordship.
Yes,
Oblige,
call
lordship.
the list.
Now you got the 20. Come.
Lordship. Oblige, lordship.
Yeah.
Genuinely obliged. But I am for the petition.
Yes.
My lord, this is against National Insurance Company Limited. May I draw your lordship's kind attention to page 10A. Page 10A, my lord.
কে বলছে এটা?
ঠিক আছে আমার সিনিয়র
National Insurance Company, page 10A.
Page 10?
A.
Yes.
Your Lordship may be pleased to see my prayer to settle and adjudicate the insurance claims. And next B, to investigate into the issue. To investigate into the issue.
Commanding the particular.
Yes.
Now I shall draw your Lordship's kind attention to page 98, page 14. Page 14, my lord. Page 14. Your country see the preamble. Indian travel market is one of the biggest markets in the world. As per reports, around 36% of Indian households undertake trips for one purpose or other, both within and outside the country.
Which
Now, it
which
is
month
the-
you are reading?
My
Page
lord,
14.
Page 14, preamble.
Preamble, yes.
Yes, Indian travel market is one of the biggest markets in the world. As per reports, around 36% of Indian households undertake trips for one purpose or other, both within and outside the country. It is desired that all travels undertaken should be safe. There is a need to make every trip financially secure by providing suitable protection cover against unknown contingent events. Though there are a number of travel insurance products available in India, each product is distinct and the insuring public may find it difficult to choose an appropriate product. Therefore, a standard travel product is designed with uniform features or coverage so as to make available the most requirements of common passengers. Now I shall turn your lordships to page 98, my lord. Page 98. Lord, this is the letter sent to Chief General Manager with copy to National Insurance Company Limited. Now, my lord will be pleased to allow me to turn page 100, fourth paragraph from top. That the insurer, after receiving such a presentation, had mailed me on 18th April, stating that my claim has been referred to General Insurance Council. However, I have not received any further communication from the said insurer. Now I shall beseech my lord to kindly come to page 131. Page 131.
No, page 100, which paragraph you are relying upon?
Page 100, my lord.
Yes, page 100, which paragraph you read?
Lordship, give me a minute. Give me a minute, my lord. Page 100, fourth paragraph, that the insurer, after receiving such representation, had mailed me on 18th April, stating that my claim has been referred to General Insurance Council. However, I have not received any further communication from the said insurer.
Yes.
My lord, I shall now
My lord, may I submit, my
to
lord?
kindly allow me.
Matter has become infructuous, my lord. This representation has been considered.
No.
They have received the
No,
money.
my lord, your lordship,
My
my
learned
lord,
friend.
it is not that easy. My lord, kindly come to page 131. Kindly come to page 131, my lord.
Yes,
Kindly
just
come to
Mr.
page
Mr.
131.
Mr. Ganguly, you have gone through the decision taken by the authority, insurance company.
No, my lord.
Received the
It
money,
cannot
my lord.
be. Kindly come to page 131.
Just a
Kindly
minute,
come to page
just a minute.
31. Kindly come to page 131, my lord. I beseech your lordship. Page 31, decision portion. Page 31, decision portion. Whenever delays have taken place in taking decision on the settlement of death claims, it is considered insurers failed to adhere to within the referred regulations. The violation of referred
My lord, this writ petition was filed, my lord, when the representation was pending, my lord. After the filing of the writ petition, the amount has been satisfied, my lord.
has come to conclusion, just and proper, impose a penalty of 5 lakh. Accordingly, a penalty of 5 lakh imposed on HDFC Standard Life Insurance Commission Limited. Now kindly come to page 132, madam. The penalty amount of 5 lakhs shall be paid
complete
in a
order.
period
My
of
lord.
appeal.
Where is that?
My lord, one single sheet is there, my lord, where he has agreed, my lord.
your
One
lordship, may
single
be
sheet.
pleased to allow me to place
Joseph
for you
Dylan,
page
my lord.
132. My lord, kindly see page 132. I shall
But
beseech your
Mr.
lordship.
Mr. Ganguly, have you received the proper instruction from your client? Your client has received the amount of rupees to 10 lakhs. I agree to
That is
receive
unknown to me. Let them communicate. But prior to that, kindly come to page 132.
My lord,
once for my
with due
instruction.
respect to my
I
senior,
beseech
my lord,
your
may I
lordship.
submit before your lordship
Kindly
one
come to
thing?
page 132.
your junior is taking leave from you to submit something before this court.
My lord, the amount has been given. That claim has been settled. But my lord, that has not been settled in accordance with the guideline that has been passed by the IRDA. My lord, kindly see
That is
the
a new cause of
guideline.
action then, my
No,
lord.
no, no. That is the guideline. The amount should be settled in the jurisprudence, in the ratio that has been settled by the IRDA. This is something, my lord, kindly comes to, my lord, page number 45.
My lord,
I have
kindly
marked,
comes to the prayer, my lord. Instead of wasting the time, kindly comes to the prayer, my
to
lord.
the page
It was
number
only
45.
Correct. See,
Lordship.
now they have you, as per your prayer A, to consider
The representation, my lord. I'm grateful, my lord.
Consider 10 lakh rupees awarded.
Lordship.
You are satisfied in your receipt. You are
Lordship.
saying that you are having any grievances with regard to the contention of they have not proceeded in accordance with law,
Lordship.
which is provided under the Insurance Act or insurance policy.
Lordship.
You have a present
New
New
cause
course of action.
You are free to take appropriate action.
My lord.
My lord, one thing I would like to take my lord to this particular guideline, my lord, that is, my lord, kindly comes to page number 45. I do not even have to apply for that. What is happening, my lord? My lord, point number 45.45 of this one. Yes, the Master Circular on Protection of Policy Holder Interest 2024. If my lord sees, my lord, kindly point number 3, sub point number 2, my lord.
Page 45.
Page 45, my lord.
Yes.
Lordship. 45 of this guideline.
Correct.
45 to alada acha.
Lordship, now this
Processing of claim.
processing of claim, my lord.
Correct.
In case the claim is not settled within the specified timelines, then the claimant is entitled for interest at bank rate plus 2% from the date of receipt of the of information to till the date of payment.
Correct.
My lord, such interest shall be paid by the insurer suo moto. What I'm trying to impress upon my lord, that is, my lord, I do not even have to beg for this. I do not even have to apply for this. When my claim is getting settled, that, my lord, is to be settled in suo moto manner in accordance with the law and along with the, my lord, interest. My lord, that has not been done, my lord. What I pray before your lordship today, that, my lord, if my lord gives an instruction, if gives an order, my lord, that is to be, if the amount is to be settled or amount is to be paid, that is in accordance with the latest guideline, that is this
I
guideline.
am disposing of, you have received the 10 lakhs, you are claiming the interest in terms of this, and insurance authority can consider these provisions and pass appropriate order.
My lord, I object.
No, you
deeply obliged.
consider and you pass
My lord,
appropriate order.
my lord, allow me to submit. Yes. They have received this amount, my lord, by signing the discharge voucher, my lord. That also means something, my lord. They have left every claim about, then only this amount has been settled, my lord. Without prejudice of their rights, my lord. Now they come to the court with a prayer before receiving this amount to just consider their representation. Representation has been considered, whether it was good or bad. Thereafter, they have received the money by signing the discharge voucher, my lord. Now they cannot agitate all these before this writ court, my lord.
These things cannot be settled orally. Let them tell by affidavit.
Okay.
This cannot be settled orally. Let them file by affidavit.
Okay.
Dealing with all my contestants, particularly, my lord, page 130.
My lord, they have not disputed that the representation is not considered. Nothing is left, my lord, in terms of the prayer.
No, my lord. Let them say so
Impress upon your
by
lordship.
filing an affidavit.
What I am trying to impress upon your lordship, that is the word, that is the direction, that is to be done suo moto.
But the problem is that the discharge voucher which your client has signed in this in the last paragraph, in consideration of such payment, I hereby absolve the company from all liability.
That I understand, lordship, but I'm leaving it upon the.
If you
My lord,
sign this without the prejudice,
my lord,
in the worst case, even if this discharge voucher was not signed, my lord, in terms of the prayer, my lord, the prayer is simply to consider their representation. They do not dispute that the representation has not been considered. Nothing remains in the writ petition, my lord.
I am a claimant, and I hope, I expect that the insurance company, they will settle the claim in accordance with the law. And where it is written, my lord, in suo moto manner, they will be doing it. But I am leaving it upon the magnanimity of your lordship. Now, I am, my lord, a claimant. If any discharge voucher or anything being signed by me on the said terms and condition which is infringing the existing law, my lord, then my lord kindly sees, my lord, as deems fit to your lordship.
So when the claim was lodged?
Claim was lodged, my lord.
When the claim was lodged?
Representation.
That is 98. That is a consideration. Request for where is your claim?
In May 2024.
Where is the claim?
N325, my lord.
Where? Which page?
My lord, in the list of dates, it is written noticing the delay in the claim settlement procedure. The petitioner made a representation to the appropriate authority of the National Insurance Company Limited for settlement of the
That is
claim.
a representation.
Where is the claim? May 24.
May 24, May 2024, the paper, that has not been annexed, my lord. Only the insurance policy paper that has been annexed, my lord.
That's why. Where is the claim? What is the claim? Should have been mentioned here. Record enclosed here. That is not here.
Huh? No, I have. But I beg you sincere apology, my lord. My lord, this claim letter, I have to make a letter to the insurance company and they would be adjudicating that. That, my lord, has not been annexed in the writ petition.
That's what I'm telling.
Lordship.
You stated that May 24, paragraph 10, you stated that in the month of May 24, after performing the last rites, you initiated the proceedings.
Lordship.
But that claim petition, what is the claim? What is the claim you raised before the insurance company?
My lord, may I come back with the claim
And in the
later?
claim, your claim for the interest. Okay, I am disposing of.
Lordship.
My lord, my humble submission, my lord, kindly do not grant any liberty, my lord, because they will give rise to new litigation of a dead wood, my lord.
Why you not provided this insurance, the interest?
My lord,
Why you not provided the
my lord,
interest?
they have signed the discharge.
May sign the discharge, sir. May sign the discharge. Leave aside this if the MSCC case is filed.
My lord,
And the tribunal has passed an order.
my lord, kindly appreciate, my lord. It is a contract between the parties, my lord.
Yes.
Now he has agreed to take that amount, my lord.
But you have to go by the law also.
My lord, he has agreed.
2% May 2024.
My lord, kindly appreciate, my lord. It is a contract between the parties, my lord.
There is a settlement. He has settled the
My lord, he has settled. I have presented the documents, my lord. He has
received an amount.
no, my lord. He has received the amount with regard to all his claim, my lord.
Yes, whether he has given the settlement.
My lord, he has signed the discharge voucher, my lord.
Discharge voucher, this is your format. This is a format of the insurance company. Whatever you pay, then you have to take the signature. The illiterate person has to sign and take the amount. They don't know, but they find that your 10 lakh rupees enough. But with regard to, they don't know the law. Now it has come to the court. Court has to see.
My lord, kindly appreciate. After signing this discharge voucher, my lord, have they complained that this voucher has been signed on coercion, my lord? Whether they have made any complaint with regard to this. Since this writ petition is pending now, my lord, they want to give rise to a new litigation. by coming before this court by saying that we did not get the interest. And even, my lord, with the greatest of respect, my lord.
You have compelled the petitioner to go to the court for disposal of the claim.
My lord.
Why you not dispose of
My
the
lord,
claim at the very stage when you have received the
My
claim?
lord, we have to verify it, my lord, whether the claim is legible or not, my lord.
When you have received the claim May 24, when the writ petition, this writ petition was filed 2025, 1 year you have taken for the verification of the claim.
My lord, something is out of the record, then I have to bring before this court, my lord. He has number of insurance policy against this travel insurance claim, my lord. That is why there was a delay, my lord, because he has received more than 3 crore rupees, my lord.
No.
From different insurance company, my lord.
Absolutely.
That is why I'm not, my lord, that is why I'm not going into the facts of the case, my lord. But
you cannot can you receive the 3 crore rupees, that's why you know not.
My lord, I'm not complaining with regard to that.
I am not impressing on other fact.
My lord, his writ petition was Kindly allow me to submit. His writ petition was, my lord, only to consider his representation. We have considered the representation. Nothing remains in this writ petition, my lord.
Thank you. CAV. Getting concluded, CAV.
Lord,
great.
I'm grateful to your lordship.
Item 22, tomorrow it will be. Tomorrow the same list will come. Yes, call the list.
With my lord's kind permission, my lords, there is an item 26 and 27 of appellate list.
My lord has fixed for cross-examination of my witness at 3 o'clock.
With my lord's kind permission, my lords, there are 2 items of appellate list, my lords, 26 and 27.
Come tomorrow.
My lords, only request to have it higher on the board, my lords. This is the third
Yes, it
date.
will come higher only today already 20. Your matter will be a 7.
I'd like to
Much obliged, my lords. Much obliged. Much obliged.
mention the matter, original site. Mention the matter, my lord. WPU 530 of 2025, my lord. I'm paying for matter be listed because the stay order expired on 28 of September, 28 November 2025, my lord.
To be mentioned,
Prior notice.
Item number 34. Petition has taken
Appellate side.
No, original. Appellate.
Original site.
Original side no, only evidence will be taken.
going
You have taken
downwards,
the resolution of 330. Today it will not be taken.
Let it be tomorrow, anytime.
Yes, it will remain in the list. It
But
will
it's going
be in the
downward.
list.
Gradually it is the
Let me see. Yes, start.
I'm for the plaintiff, my lord.
Dependent is direct to pay rupees 29,69,527 along with interest at the rate of 10% from 12th October 2021 till the realization of the total amount along with the cost of rupees 75,000.
Grateful, my lord. Deeply obliged. Don't intimidate.
Item 2.
The interim order is absolute except the insurance policies.
And Lordship has been pleased to allow them to liquidate the insurance policies.
Yes.
But they will come into the same bank account. Your Lordship would need to direct, otherwise they will take away that money.
Accept the insurance policies. I passed an order. The interim order granted by this court date 12 is made absolute except the amounts involved in the insurance policies.
Your Lordship has allowed the insurance policies to be taken out by them.
I am not allowed. In insurance policy, no injunction has been granted.
Lordship, may I request for a limited time stay to this order for us to consider it, Lordship.
Record. Counsel for the petitioner. Press 4. History of the operation of the interim order. Who is for the other side?
Really, my lord, Mr. Dhruva Ghosh is appearing.
The court considers submission. Prayer is refused. Next.
Lordship has been pleased to decline.
Junction is made.
Item number 3, I am for the petition, my lord.
Yes, why are you mentioning?
Here, my lord, in this matter, lordship, I mentioned upon notice upon the Mr. Sinha
this is the matter where the affidavit has been exchanged. The matter is ready for the hearing. Earlier, we have filed one testamentary application.
What you
A
want?
hearing of the matter, Lordship. Everything is ready, Lordship. State is served. Mr. Sinha was there. If you Lordship remember, he asked for some time. We wanted to find out who will appear as the senior in the matter. Earlier, Mr. Amitesh Banerjee was appearing.
कब रखिएगा इसको? 3 p.m. 16th December, 3 p.m.
Grateful, Lordship.
We got an order.
Grateful. Appearance.
The matter is listed as to be mentioned on the prayer made
I am
by the
appearing
counsel.
on behalf of the state respondent.
Date fixed.
Today, my lord, I have filed my lord affidavits.
Okay, I am fixing on 16th.
16th.
My lord, kindly.
Let the matter
Look, affidavit or reply?
be mentioned on the prayer made by the counsel for the
Reply or reply?
for the plaintiff petitioner.
Original though.
And prayed for the counsel for the petitioner prayed for fixing the matter for the
Reply to.
counsel for
Today,
the
file.
respondent file counsel for the estate file affidavit in opposition.
Reply file क्या बना?
Listen, let the same be kept with the record. Let the same be. This is the matter on 16th of December at 12. At 2
3 p.m. Lordship. 16 3 p.m. Lordship. Grateful, Lordship.
Next.
মেরে কিছু না ওরা তারা ইন্টিমিডিয়েট করতে পারবে
They are the plaintiffs.
হ্যাঁ let them go there and ask
What is this?
the corrections.
The corrections. The depositions of the witnesses here.
Yes, start.
There's some Sandeep Sethia. There are some.
Mr. Dutt with his towering personality is trying to intimidate my witness being proximity to the witness.
If the that is not been allowed to.
Only the difficulty is that the boards are not difficult.
Yes.
এগুলো তো ওদের আগে দিতে হবে না আর ওরা করে
Yes, as far as the corrections are concerned, we have done the entire deposition corrections. I'll sit with Mr. Dutt.
If it is concerned, it will be done. There is a dispute, then we'll go.
In color, it's in red. No.
the corrections আছে তো
Different font.
হ্যাঁ হয়ে গেছে
পুরো একসঙ্গে দিচ্ছি আমি দেখে দিচ্ছি
SUN
since today is only half an hour, tomorrow we can complete that.
Yes.
written statement.
Mr. Setia, can you recollect to who has affirmed the written statement in this proceeding? You don't have to, I'll give you a copy of it. Kindly have a look at the written statement and tell my lord as to who has affirmed the written statement, verified and affirmed the written statement.
This is Mr. Jona Bhatlu Bhanumurthy. This is a statement of the bank.
Written statement, written statement.
Written statement though.
Hey?
In the contract link, but written statement.
Written statement comes out.
Written statement or dependent.
Mr. Kamal Singh Bed.
Is he still a director of the defendant number one company?
No, you asked me earlier. He's deceased.
Deceased. And who are currently the directors apart from you in this company?
My mother,
You and your mother. Naam karo.
Shanta Devi Sethia. Or Shanta Sethia. Shanta Sethia only.
Now, do you recollect as to who were the directors of the company in the year 1984, 87?
Yes.
Could you please tell my lord as to who were the directors?
Mr. Sukamalendu Chatterjee. Mr. Sukamalendu Bhattacharjee.
Yes.
Mr. Bhattacharjee. Mr. S.K. Bhattacharjee. Mr. D.R. Bed. Mr. B.R. Thapar. These are the names I can remember.
You can recollect it. But I believe at that point of time, your evidence is that it was a public limited company.
That's correct.
So who would be the other directors?
These were the three directors. I think I may be more than three, but I can recollect three. As per law, it needs to be a minimum of 3 directors. It was a closely held public limited company. Held.
Was your father a director of this company?
My father has never been a director or a shareholder of RK agencies.
And those people who were the directors at that point of time, i.e. 1984, none of them are alive?
No.
Is there anybody in the company who is still alive who could depose as to what happened in the year 1984?
Other than me, you mean? I am there.
You're the only one. Now, are you sure that in 1984 you were involved with the affairs of the company? Defendant number one company?
I was living in England at the time, but when I came to India, I used to meet with Mr. Bhattacharjee and used to take the details of the business from him.
When you say that you used to take details of the business, what do you mean? How was the business running? What is the profit and loss, or more than that?
In general, everything related to the business. There was a tea garden which was being managed, so I would look at the reports of the garden. Reports of the activity, and I discussed matters with him. Matters with Mr. Bhattacharjee.
Apart from gathering general information from Mr. Bhattacharya. Did you discuss the facts pertaining to this case with him?
I discussed it many times with him over the years, but I cannot recollect exactly when and what was discussed.
When and what? Now, I am once again drawing your attention to Exhibit A3, A by 3, being a letter
A by 3
of Khanna and Company dated 27 November 1984.
Judges prefer one.
Plain করে আগে শুটে না ওটাতে এখান থেকে
হ্যাঁ 151
এই শুটে
এইখানে আছে
Yes, what is the question? I am also showing you the plaint filed in suit number 297 of 1987, which would be at page 155, volume 2 of the judge's report documents.
One by
Now, kindly come to paragraph 3. Where you have stated that on 1st December 1984, a letter of lien on a printed form of the defendant was executed on behalf of the plaintiff. Now, this lien, according to the plaintiff, was created by way of a fixed deposit under cover of letter of 28 November 1984. Am I correct?
Yes.
Yes. Do you still stand by the statements made in paragraphs 2 and 3?
Yes.
Yes. So you will agree with me that the statements made in paragraph 4 would also be correct?
Yes.
So you are not disputing the fact before this court that the sum of rupees 20 lakhs was to be transmitted, of which a lien was created, was to be transmitted to a foreigner's account in London.
Is that the
Yes,
yeah.
that.
I would only add that it was always the right of RK Agencies Limited to transmit or not to transmit the sum of 20 lakhs to the foreigner's account. There was no obligation to the bank to do so.
No, no, আগেরটা কি বললো? It was only, I would only add First he said yes, he agrees. You agree with that statement?
I agree.
Yes. Then add, I further add.
Adds.
কি বলছি?
Please go slow. Go slow.
Did I answer it again? Yes. Shall I repeat it? I would only add that RK Agencies Limited was not under any obligation to the bank to transfer the money to London.
But the fact remains that you wanted to transfer this money to some foreigner's account in London, for which the lien was created in favor of the bank.
No, they are two separate things. A lien was created.
Go slowly. Huh?
The meaning and purpose of the lien has already been adjudicated. RK Agencies Limited intended at the time to transfer the money to London to a foreigner's account. RK Agencies changed its mind and demanded refund of its money on the 28th of May, 1985.
Now, kindly come to A3. Plainta hoye gache. Plainta you can give it. You will find that RK Agencies had created the lien under cover of this letter by a check number J148553 dated 27 November 84 for rupees 20 lakhs drawn on Allahabad Bank. Am I correct?
No, the lien was created 4 days later.
I said intended to create a lien.
You said, was it created by
Intended to create. Intended to create.
So could I?
Acha, I'm very sorry. I stand corrected. Intended to create a lien.
Could the whole question be
The
repeated?
please question. Please question. Intended to create a. Am I correct? Am I correct?
It appears so.
Yes. Either say yes or no. It appears so means that something else. But I told him to say yes, it appears so. Otherwise, it appears so means I don't know. So, are you in a position to tell my lord as to who on behalf of RK Agencies issued this check for rupees 20 lakhs?
I cannot say for sure. Almost certainly, Mr. Bhattacharjee would have been one of the signatories.
Although?
Almost certainly, Mr. Bhattacharjee would have been one of the signatories.
If I put it to you that in the previous round of litigation, Mr. Bhattacharya could not recollect on being questioned as to who issued the check. Would you agree with me?
It's a matter of record.
Can you tell my lord as to whether RK agencies had an account with Allahabad Bank?
Yes, it did.
Yes, it did. If it is your case, if it appears from the letter of 27 November 84 that this money was deposited by way of a check with Central Bank of India, would I be correct in understanding, in believing that the person in whose favor the lien was supposed to be created was an existing customer of Central Bank of India?
Absolutely not. If you read the letter of lien, it is created in favor of the Central Bank of India.
So, if it was created in favor of Central Bank of India, does it not necessarily imply that it has some connection with business of Central Bank of India, with the banking business of Central Bank of India?
It would imply that the bank could use the money if it had a claim against RK Agencies Limited. That's all.
Sorry, did RK agencies have any account with Central Bank of India?
Yes, RK Agencies had 4 accounts with Central Bank of India.
4 accounts with Central Bank of India.
There was, I can list them. There was an account at Brabant Road.
Yes.
There was an account at Dimakuchi in Assam. Dimakuchi. There was an account at Tangla in Assam. And it may have been 3. Sorry. I can't remember.
So it is your considered evidence that RK agencies was also a customer of Central Bank of India.
It is a fact.
And SL Setia Liners and Ramplace were also customers of Central Bank of India.
Yes, it seems so.
It seems so.
I said yes.
But at that point of time, RK agencies did not have any foreign account with Central Bank of India. Am I correct?
No.
I'm not correct.
No, No, it did not.
Did not. Now, kindly read with me the balance portion of the letter which starts with an inverted commas. With Bulbo, in our favor, invited commas. Request to have the check encashed and put the proceeds thereof in a short-term fixed deposit
for 6 months. Carrying your
for
usual
6 months, carrying usual interest. No, stop. The fixed deposit receipt may be kept under lien by the bank, and if necessary, we will formally discharge the same in favor of the bank. Full stop. Can you recollect? No. Can you recollect now? Would I be right in saying that at that time, RK agencies had intended to create a lien with this sum of 20 lakhs in favor of Central Bank of India?
Yes, it appears that RK agencies intended to transfer the sum to a foreigner's account at its own discretion, subject to permission of the Reserve Bank of India.
So, would you agree with me that the creation of the lien over the sum of 20 lakhs had nothing to do with obtaining permission from Reserve Bank of India?
No, I would not agree with you, because once the Reserve Bank of India denied permission, all of this became irrelevant.
In other words, if I say that you intended to create a lien in favor of a foreigner's account under cover of the letter of 27th November 1984, and that money could only be transferred to that foreigner's account subject to getting proper permission from RBI. What would you say to it?
There was no lien in favor of a foreigner's account. And the rest of the question becomes superfluous.
There was no?
In favor of a foreigner's account.
Other question and become
My question to you was that you intended to secure by way of lien a debt in respect of a foreigner's account.
No, I disagree.
You mean the plaintiff, sorry, I
disagree. I'll just leave it at that. I disagree.
I disagree. I further put it to you can you tell my lord, no, you have just deposed before my lord that the RBI permission RBI did not grant permission for transfer of the money.
Correct.
Now, had the RBI granted permission, to whom would the money be transferred?
Actually, it was never decided to whom the loan agreement never took place, because before any loan could take place, the potential agreement vanished, and we asked for the refund of our money.
So it is your considered evidence before my lord that RK agencies wanted to create a loan account, but since the RBI did not give permission, therefore this money could not be transferred and the consideration for the same failed.
No. The RBI refused permission after the potential agreement had collapsed. The bank applied to the RBI of its own volition and was denied.
Was denied.
Was denied. Now, therefore, from your evidence, it appears to me that apart from the directors of RBI, of RK agencies and Central Bank of India, nobody would have come to know of this attempt of yours to create a lien. Am I correct? Nobody else would have come to know of this attempt of yours to create a lien. Nobody would have come to know about this letter of 27 November 84 and the lien.
Apart from?
Apart from RK agencies, directors of RK agencies and Central Bank of India.
I don't think it was a secret, so I don't know who else knew in 1984.
How come? Now, can you explain as to how the fact of creation of this lien came to the knowledge of the solicitors of SL Setia Liners and Ramplace, being Zaiwala and Company?
Zaiwala and Company, according to the records, were the solicitors of SL Setia Liners Limited and their co-defendants, KC Setia 1944 Limited, in a suit filed by the bank in London. They did not represent RK Agencies Limited. They did not represent Drumplace Limited.
My question to you was...
So I cannot say how they came to know about this 2 million rupees.
Okay. But your father was a director of SL Setia Liners.
Yes, he was.
He was. And in his capacity as director, no, Ketadi, and Zaiwala and Company, being advocates of SL Setia Liners, would have received instructions from the company, including your father.
Zaiwala and Company came into the picture after the bank filed a suit against SL Setia Liners Limited on 30th of January 1985. They wrote a letter to the bank on the 11th of February 1985 and demanded credit for 2 million rupees, exactly 2 million rupees, no interest, to the account of SL Setia Liners Limited, which had been deposited with the Central Bank of India at Calcutta. On 29th of May 1985, Stocken and Lambert, the solicitors of the bank, rejected Zaiwala's application, and on 4th of July 1985, Zaiwala withdrew his proposal and filed a counterclaim to the suit of the bank against SL Sethi Liners Limited.
Is it also a matter of fact that the same amount of 20 lakhs was sought to be adjusted, was attempted to be adjusted in the as set off by Drum Place and Company Limited in a suit filed against them before the Queen's Bench in London?
There is nothing on record that says so, and it would appear from the record that Drum Place Limited was undefended in the suit filed by the bank. So I think that is probably incorrect.
Do I continue now or continue tomorrow?
Your choice.
It's 3:30.
That is of the bar, not the court.
Come back tomorrow. I think I'll be able to discharge.
Counsel for the defendant is present. Cross-examination resumed, but due to paucity of time, cross-examination could not be completed. Cross-examination is kept off. Let the matter appear tomorrow at 3 p.m.
May I have your lordship's kind leave to mention item 108 of your lordship's list. Lordship, this is a specially assigned matter, CSC Limited versus 3 chairs. My lordship. 108, your lordships.
Yes.
I'm being led by Mr. Ghosh, your lordship.
No, this is that only my reply is left, the defamation against that television company. Only, just one, I argued for 2 days and then this, I think again 6 months have passed. Anytime in December, if my lord keeps it.
Date hai. 2 p.m. 3 p.m. 19th December 3 p.m.
Lordship, lordship,
May it be 17th, 18th and 19th, there's a wedding.
It's already fixed, na?
22.
22?
Last.
They got an order.
We'll give our notes and we'll finish.
Yes. 108.
108.
As per the submission made by the council.
lordship, may I kindly be permitted?
Let the matter appear on 22nd December at 3.
Lordship, may I kindly be permitted to mention a matter out of extreme urgency? Lordship, matter is running in the daily list. Lordship, anytime the railway authorities may daily list item 29, Lordship. Anytime the yes, or appellate side, Lordship. Lordship, the matter is that the petitioner has been in the possession of a cycle garage for past 40 years in Barashat railway station in Shialda Southern Division, and the petitioner seeks to continue the tender. 29, Lordship.
29, it will taken tomorrow.
Lordship, tomorrow anytime if it may be fixed, Lordship.
Come tomorrow. Today already I reached 20. So it will come within 9 or 10.
Right, may I have your lordship's leave? Wanted to mention original side, item number 76. This is the contempt matter which my learned friend is on the other side. He was to reply. Well, urgency is on our part, but the lordship could kindly give it some 76. So it's the Sanei matter where the contempt application has been filed by my learned senior friend. Yes, Manoj, sale deed. Gift deed, not a sale, gift deed. But Mr. Ghosh is supposed to reply. But any day if you it is, but it is way down.
Let's take our chances, Manoj.
If your lordship could give it some precedence for that any day, for that.
Wait 1 week, then we'll see.
Very
Wait for 1 week.
Very good.
Your lordship, kindly grant me leave to file this application. This application has come notarized from Delhi. Only one part, like the affidavit portion.
What
that is-
application? Writ application?
Writ application. Lordship.
What you want?
The petitioner has been arrested like in a illegal and in a very malified way.
You challenge the arrest of the petitioner. So why here?
Lordship, it's a
Police in action.
But Lordship, we are filing in the original site. So
Original site?
Original site. The police station is Bow Bazaar.
Original, you are filing the writ petition before the original in the original site.
Lordship.
Why are you not going to the appellate site?
Lordship, it's an instruction from my, I can't help it. Can you please,
Okay,
Lordship,
fine.
allow me the leave? If your Lordship, please. The department is not accepting only for
Show
the...
the prayer, show the prayer.
Why in the original side? Go to the civil
But
side.
the
police
police
inaction.
station is Bobada. We have actually instructed that it is coming from Delhi. So,
From Delhi, it's okay.
I'm also under instruction over here. Lordship, may please allow.
That's why. Because police in action, there is no determination. If it is not police in action, it is regular suit coming under 9. I can
understand.
Right,
But
it is not coming under residuary.
I can understand, sir.
I cannot go to the other.
Lordship, may I be permitted to mention item numbers 8 and 9 of your Lordship's daily list original site? It could not be taken up today, Your Lordship. These are two connected rates seeking for reconnection of electricity. My electricity supply to a commercial building has been cut.
Tomorrow it will be up, na? After tomorrow.
So item 8 and 9, some precedence because I am without electricity.
9, I will take.
Lordship.
Your Lordship. Your Lordship, my matter was appearing today for hearing in item number 6. My matter is very urgent. It's in regard to the. Yeah. Yes, sir.
This matter actually, my lord, pertains to Public Premises Act, my lord. And my lord, this, my lord, subject to correction, should go before the bench of Justice Om Narayan Rai, my lord. It's arising out of Public Premises.
But it's in regard to the auction. It's in regard to the auction.
But
The
under
determination.
the Public Premises Act, my lord, then that court has.
What is the prayer?
My lord, they are
The prayer is
seeking-
for the material, handover of the material, sir.
My lord, they are seeking, my lord. Just a moment. My lord, they have sought, my lord, the direction to hand over the goods, my lord, that were lying in the property that was taken. And my lord, prayer C, my lord, they are asking for quashing and cancellation of a publication and advertisement of auction under the Premises Act, my lord, the Public Premises Act.
But it's in regard to the auction.
Understand, but my lord,
Residuary.
everything
It comes
in
under. It
connection-
falls under residuary.
Otherwise, there is nothing. Otherwise, in a writ petition, my lord.
Where is the auction notice?
They have not given us any auction notice, sir.
It is there.
That is in the name of Burn Standard
From the
Company.
publication of the auction dated.
Sir, it's in the name of a company which is non-existent.
P26, my lord, that page 210.
Sir, this notice is in the name of a company which is non-existent.
My lord, may kindly see it has been issued under Public Premises Eviction of Unauthorized Occupants Act
This
1970.
notice has got no legal existence.
Yes, you challenge that. How took this code? 210. Public Premises Act. Recorded note. Item number 6. 6. Counsel for the respondent. Draw the attention of this court to the notice appearing at page number 210, which is issued under the Public Premises within bracket Eviction of Unauthorized Occupant Act 1971. Consider the above, this court finds that this court is not having the determination. Accordingly, writ petition number WPO number 821 of 2025 is released from the list of this court with the liberty to the parties to mention before the applicant.
So your lordship may not have any interest in the matter anymore, but your lordship's order in statesman has been upheld by the Supreme.
Which one?
Statesman matter. Upheld.
Thank you.
I just thought I